This hearing
Lahu
involves
dakuma.
the resumed evaluation of Mr. Victor Sandu, candidate for the Superior Council of Magistracy, judge at the Chisinau District Court Central Office. I would like to welcome you, Mr. Sandu, and the Commission also welcomes Mr. Zama, counsel for Mr. Sandu, during the hearing today. We are here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of Magistracy. The Commission is acting in accordance with Law Number 26/2022 and its rules of procedure. On the screen in front of you, you have the four members of the Commission: Victoria Henley, Nadeja Rybczewski, Nona Tsotoria, and myself, Herman van Hebel, the Chair of the Commission. The Commission is assisted by members of the Secretariat, and the online public hearing can also be followed by representatives of the media and the public. During the hearing, interpretation between Romanian and English will be provided. To allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded and the public parts will be available online, generally within 24 hours after the hearing, via the website of the Commission, www.vetting.md. I will start with a brief overview of the procedural background of this resumed evaluation. On 18 January 2023, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Magistracy. In its decision, the Commission decided that it had serious doubts about your compliance with the criterion of financial and/or ethical integrity in relation to issue number 1, import and registration of vehicles, failure to declare income from the sale of vehicles, and non-payment of taxes on income from those sales in accordance with tax legislation, and issue number 2, transaction involving a Mercedes E220 CDI car. On 8 February 2023, you appealed this decision to the Supreme Court of Justice. On 1 August 2023, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 9 September 2023, the Commission started the resumed evaluation. On 29 March 2024, pursuant to Article 19, Paragraph 1c of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 5 April 2024, you responded in writing to the statement of facts and serious doubts. On 15 May 2024, the Commission sent you addendum number 1 to the statement of facts and serious doubts in relation to the 2 issues previously sent, as well as an issue number 3, namely the extension of pretrial detention of Sergei Kosovan in spite of his terminal illness and insufficient reasons given for extending his pretrial detention. On 22 May 2024, you responded in writing to this addendum. On 11 April and 22 May 2024, you informed the Commission that you wished to participate in a public hearing. On 12 July 2024, you submitted a request for the recusal and dismissal of myself as member of the Commission. The Commission has deliberated on your request. The Commission determined that I shall not be recused from this evaluation, as the request for recusal was submitted untimely and as there are no grounds to doubt my impartiality regarding your evaluation. The Commission has also concluded not to withdraw my membership in the Commission, both because the request for membership withdrawal was filed untimely and is ill-founded and lacks legal grounds. A written decision will be sent to you shortly. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request. The hearing will be focused on the statement of facts and serious doubts that the Commission has sent to you and your written response to the statement of facts. I will briefly explain the procedure for today's hearing. For each issue included in the statement of facts and serious doubts, you will be given, if you so wish, a maximum of 50 minutes to briefly provide additional explanations to complement your written response to the statement of facts and serious doubts that you submitted to the Commission. One or more members of the Commission may have questions for you about the explanations you have provided, both in writing and during the hearing. I urge you to be concise in your explanations and answers. I also urge you to answer all questions truthfully and completely. Your explanations are important to the Commission in verifying your financial and ethical integrity. Pursuant to Article 12, Paragraph 4, Letter A of Law Number 26/2022, a candidate has the right to be assisted by an attorney or a trainee attorney during the evaluation procedure. Law Number 26/2022 does not state that the candidate has the right to be represented by counsel. Therefore, if during the hearing you would like to consult your counsel, please indicate this to the Commission and we will briefly interrupt the proceedings to allow for such consultations so that you can answer any questions raised by the Commission or make any statements in accordance with Law Number 26/2022 and the Commission's Rules of Procedure. I would like now to hand over to Nadezhda Rybczewski to lead the discussions with you on the statement of facts and serious doubts. Nadezhda, you have the floor.
Thank you, Mr. President.
I apologize. May I intervene?
Please go ahead, Mr. Sandu.
Hello. I would like, the first matter, I would like to have an attorney's document. Well, it's a document proving that he's my attorney today. It's a document for you to be attached to the file. At the same time, I would like to, and you made reference to Article 12, if I'm not mistaken, of the Rules of Procedure, to be assisted. Article 12, Paragraph 4, Letter A of the law, not regulation. Yes. So it says assisted. I request for him to be granted the possibility to provide to me legal services. That's what he's paid for. He should be provided with a computer and a camera turned on so that he would be able to intervene. We will not need to make interruptions. I also have higher education in the field of law. I want him to be present and, if needed, for him to intervene. This means this is what means to be assisted by an attorney, and this is the type of services that attorneys provide in Moldova. If I'm not mistaken, Nadezhda, you are an attorney by education too, right?
Aren't we all, Mr. Sandu? But in response to your question, as I mentioned in my introduction, there's a distinction between being assisted and being represented. And as I indicated, you will be entitled to be assisted, as Law Number 26/2022 does provide, but not to be represented. So the Commission has determined that the only one that can communicate with the Commission this afternoon is you, because you are the candidate for this evaluation. As I mentioned, if you would like, of course, you can consult your counsel, but questions are being answered by you as candidate and not by your counsel. That is the procedure that the Commission has agreed, and I hope you will agree with that process. Nadezhda, you have the floor. Please go ahead.
Merci. Bună ziua, domnule Sandu.
Thank you. Hello, Mr. Sandu.
clarificat.
I hope this clarification was enough. I did not finish what I was saying. I just want, in this case, to ask that in the decision that you make, a comment that the attorney was present. He assisted during the hearing, but he was not allowed to intervene and mention, because I believe this is a violation of a right to defense provided for not only by the legislation of Moldova, but also by international law and on all continents, I think in Africa as well. Also, from what I understand, there is a representative for OSCE connected online, and I recommend that he would mention in his report that the attorney was only allowed to be present, not to intervene and not to express his position. Now, the next request. Still, I was surprised. I was about the report on the request of recusal. I'd like to inform you that according to the regulation, the moment of recusal, filing the recusal declaration is clearly provided. I wrote in the text, and I hope it was translated correctly, because I really have big doubts that it will ever, the translation to English will ever be submitted, as it happened before with all the materials. But I think that according to the national and international standards as well, I have the right to be to become familiar, to to prepare the defense. That's why I contracted an attorney. I need to know the reasons, because I prepared a reasoned recusal. I think someone may say that it is unfounded, but from my position, it is well-founded. That's my position and my attorney's position, and I want to see what aspects were examined. Did you look into the subject matter? Did you analyze all invoked methods? Because at first sight, it could be an argument, but I mentioned of two situations of incompatibility and two situations that were
Mr. Sandu, please, may I stop you here right now, because you submitted indeed your request for a recusal on Friday after office hours to the Secretariat. That was passed on to the Commission over the weekend, and the Commission today has deliberated on your written request for recusal. And as I informed you in my introduction, the Commission has taken a decision and has confirmed, and I can repeat what I said to you earlier, has deliberated on your request. The Commission determined that I, Mr. von Hebel, as the chair and member of the Commission, shall not be recused from this evaluation, as the recusal was submitted untimely, and as there are no grounds to doubt my impartiality regarding your evaluation. So the Commission has looked at it in substance. The case is now, let me finish up, Mr. Sandu. The case is now closed. The decision has been taken, and as I mentioned to you, it will be provided to you in writing shortly, the moment we have finalized. But the Commission has already taken a decision, so the issue does not have to be decided upon and discussed during this hearing. And so therefore, I would like to go back to you, and please go ahead with.
I have a question. Just a second. Let's clarify. Vivian, you said it was sent beyond working hours. My communication with the Commission very often was happening at 6 p.m. That's 1800 hours. I sent the request before that time. I did not go beyond working hours. Also, it's not clear. You say
we received your request on Friday afternoon. The Commission has both looked at the timeliness of your request and the substance, and on both grounds, and even if the timeliness would still have been correct, also in substance, the Commission has drawn its conclusion and has determined that your request for the recusal of myself as member of the Commission and as chair of the Commission was, there are no grounds to doubt the impartiality of me as a member of the Commission, and that there are also no reasons to withdraw my membership as it was ill-founded and lacks legal ground. That is the determination that the Commission has made based on your decision. So I would suggest...
Just a second, I want to finish my thought. Please give me 2 minutes. You can time it. So, if I understand correctly, you look, it's both late and ill-founded. So, secondly, there is no written decision yet. It's only a verbal one. Is that right? In this case, I would like to ask who were the members who examined the request for recusal, if possible, because I have a right to know who examined the request. Was it you? Was it another commission? Who were the members? Did you have a quorum or not? So please let me know. I want to know it. This would be the transparency of a process. If you don't know, I can inform you in the Republic of Moldova. Request for recusal cannot be, well, unless there is a written signed document. So is there right now, at this moment, is there a written document? Maybe Ms. Nadezhda can explain.
Mr. Sandu, the decision on recusal, on your request for recusal, has been taken in accordance with the rules of procedure of the Commission. In Article 10 of our rules of procedure, it is stated in paragraph 3, in case a call for recusal or one or more members would undermine the quorum, as per Article 11, paragraph 2 of Law number 26/2022, all members take part in the consideration and decision of the recusal. If the affected members are not required to participate in order to maintain the quorum, the decision on recusal shall be made by the members of the Commission outside the presence of the affected members. As you see in front of you, 4 members of the Commission, and as the quorum is 4 members, the decision taken today by the Commission in relation to your request for recusal was taken by all members of the Commission, including myself. Of course, I have carefully listened to, I've provided my reasons and my comments, and I've carefully listened to the views of the Commission. And as you can see from the rules, we have exactly taken a decision in accordance with those rules, as the Commission has a tendency of doing. I think this is closest the decision, the question right now. Nadezhda, please go ahead with the substance of the hearing this
Let's
afternoon.
clarify, did you vote? Did you also vote?
Yes, we did vote, and that is according to our procedure as well.
Bine, atunci eu... Bine, dați vă duc la cunoștință, atunci
I would
dreptul meu la
like to inform, that's my right to reply. I know that you amended your rules of procedure more than 4 times. Moreover, this is an internal regulation. It's not a law. It's not issued by the parliament. It doesn't have to go through a legality review, but I would like to inform you that more than 400 years ago, in the 17th century, for the first time, the principle was that you cannot be a judge in your own trial. And that principle was discovered more than 400 years ago. But you, in the 21st century, apply or act contrary to that law, to a principle that was established by lawyers 400 years ago. That's unclear for me. I understand that you can amend your regulation several times a day, but I would like this to be mentioned in the decision as well. Moreover, regarding the OSCE representative attending today, I would like for that to mention that contrary to the principle of not being able to be a judge in your own trial, 400 years later, this principle was violated. Mr. Sandu, can we move on? No, I want to provide some documents now. When I just received some documents, so I want a 2 minutes break to look into it. But
Mr. Sandu, what I would suggest to do now, we have discussed the issue of recusal. As I mentioned, the Commission has taken a decision in accordance with its own rules of procedure, which have been transparent and which have been open to you and which haven't been changed lately at all, certainly not today. I would therefore now suggest that we proceed with the hearing. That is the purpose of the hearing this afternoon. We have formulated a statement of facts and serious doubts in relation to the evaluation of you as a candidate, and we would like to use this hearing in order to give you the opportunity to provide any answers to questions that we may have, and on the basis of this hearing, then come to a decision in relation to your evaluation. Mr. Sandu, if you would like to consult with your counsel, we would appreciate if you would ask permission from the Commission first to do so, rather than handing over notes back and forth. But without this, I would now please pass on to Nadezhda to start the questions on relation to issue number 1. Nadezhda, please go ahead.
Mulțumesc, domnul președinte. Domnul Sandu, bună ziua încă o dată. Documentele pe care le-ați primit.
Thank you, Chairperson. Hello, Mr. Sandu. The documents you received is nothing new. You have them in the evaluation materials. These are copies of a statement of facts and a letter towards one of the persons that you listed, only for your convenience. We thought that maybe you don't have them printed in front of you, so don't be worried. There's nothing new there. There's nothing you haven't seen before. With respect to issue number 1, and that is import and registration. Import and registration of vehicles, failure to declare income obtained from the sale, and failure to pay income tax related to the sale in line with the tax legislation. In relation to this issue, the Commission has serious doubts about your financial and ethical integrity with respect to the failure to pay capital gain taxes from the sale of Honda motorcycle in 2018, Suzuki Espana motorcycle in 2021, issue of ownership right on vehicles imported in 2009, and the issue of profit or income obtained from the sales of other imported vehicles and that were registered in your name in the period between 2008 and 2015, and the issue of your liability to pay capital gain tax as a result of these sales, including the 20 vehicles imported in 2009. So, as Chairperson mentioned before, if you so wish, before we start the questions that we have regarding this matter, you have at most 15 minutes to provide some additional explanation in addition to what you mentioned before in writing. It's up to you if you want to use these 15 minutes or not. Yes, I want to use them. Please. I will start with an introduction regarding the legal framework. I want to speak now to the international members. From what we know, you work based on Law 26 and 2 internal regulations and legislation of the Republic of Moldova. We will start from the regulation. Section 19 of the regulation, paragraph 1, letter B. If the Commission resumes evaluation of a candidate in line with the decision of the Supreme Court, provisions of Law 26 and this regulation shall be applied appropriately during the resumed evaluation column. So we are now having the resumed evaluation and the decision of the Supreme Court. So B, the Commission may send questions and requests of documents to the candidate to the extent that is necessary to clarify some methods deriving from the decision of the Supreme Court of Justice. Article 16, paragraph 1, letter C of this regulation shall be applied mutatis mutandis. This is your regulation. You approved it, which was amended at least 4 times. Not today, but in more than 1 year, it has been amended for 4 times by you. So now, again, going back to the law. With respect to Law 26. I am speaking now to the OSCE expert and to the national and international public. So the law provides in Article 8, paragraph 4, that a candidate shall be deemed to meet to comply with the financial integrity criterion if the assets were declared as appropriate as provided by the law, and the Commission finds that the wealth gathered by the candidate over the last 15 years correspond to the declared income. I am mentioning there are 2 reasons only, and in order to state that a candidate does not meet financial integrity criterion, there are only two reasons, A and B. Assets declared according to the law, and the second one, the Commission finds that the assets acquired by the candidate in the last 15 years corresponds to the declared income. I would like to inform the public that it wasn't only my assets that were checked, my parents also, my relatives, not blood relatives such as parents-in-law, my wife's parents, sister, the brother of the sister of my wife, and you didn't even find one asset that the origin of which could not be proved. That's why I wanted that in your questions and in your decisions, please explain which good, not only myself, but also my relatives, even to kinship degree number 3. What assets do I have or do my relatives have that you had doubts about the origin of it? This was not found by the Commission. At the same time, I would like to inform you that in your regulation, you provided a formula about how income is to be calculated. The camera is off. Sorry, can you hear me?
I can hear you, but the camera is off. Let's wait. Let's interrupt until the camera is back switched on. Yeah, there it is. Okay, please proceed, Mr. Sandu.
Așa, continu.
V-ați oprit că nu a fost constatat.
You are speaking about the fact that no asset was found to have been obtained not properly. Well, regarding the regulation, you've mentioned in the regulation, you've stipulated, you've introduced there a formula as to how the income and the expenses were to be looked into, and what income exceeded the expenses or the other way around. And in my experience, considering my relatives, my family, this was not established. This was not established. I mean, not even one little difference, not even that was established with regards to the assets and income earned. And that was really a red flag for me. Now, going back to the decision of the Supreme Court of Justice. But before that, though, I would like to go to the decision of the Constitutional Court, and I would like to say that that was referred to at my notification of the third attempt. The first two panels had refused to look into the notification of the Constitutional Court that is contrary to the principles of access. So it was only the third panel that has actually allowed to raise that issue with the Constitutional Court, and the Constitutional Court has actually turned out to provide a few provisions that actually have to be regarded as mandatory across the entire territory of Moldova. The decisions of the Constitutional Court are not up for discussion and are not up for debate or for appealing. And in item 190, and I would like to inform the broad public, the general public, about these particular matters regarding the ethical integrity, and then I will refer also to some of the findings. So 143, the most important. So although the specialized panel of the Supreme Court cannot force the Evaluation Commission to pass a candidate that is being evaluated, the arguments and the conclusions drawn by that court when it comes to solving appeals, they will remain mandatory for the Commission. In this case, I would like to refer to the decision of the Supreme Court of Justice, which is also mandatory. The provisions of that decisions are also mandatory in Moldova. They must be observed. So with regards to the financial integrity, I will make a specific referral. Page 30. In these conditions, the special panel establishes that the answers did not bring forth his intention to shy away from paying taxes as provided for in the law, but there is a firm conviction of the lack of capital gain and his certainty that he did not have any capital gain on the basis of which to pay taxes. So, considering your practice, you've established, though, in other cases that even if there was some mistake, some violations, you looked into whether there was intention or not. Well, then, I will not necessarily ask a question. I will rather establish that, well, I'd never had an intention to hide anything away or not to make any payments I was due. What is more, in all of my declarations of assets, I've always reported all my assets and all the income that I've ever earned. If I had any intention to reduce to reduce the size of the income of the proceeds, then I would have reduced the price and I would have sold the asset for the price that I paid myself before the repairs, and I wouldn't have had to pay anything at all. But I was fair, and I've observed my work-related obligations and the law and the declaration of assets that I've indicated annually in every declaration. I've indicated the prices that were paid on both upon purchase and upon selling assets. I had no purpose or intention to sell to hide anything. Sorry. So what is important is the intention, and then the position of the Venice Commission too is worth mentioning. And in this regard, I would like to return actually to this a little bit later. But on page 31, the conclusion of the Evaluation Commission that it has serious doubts as regards the matter of profit or proceeds out of the sale of the imported vehicles that were registered in the name of the candidate between 2008, when I was a student in the first year of education, to 2015, as well as the alleged issue of the obligation to pay capital increase tax from the sale of these vehicles, which were not mitigated by the candidate. So this was regarded to be as unjustified. The court established that your comments in this regard were unjustified. What is more, the Supreme Court of Justice also refers to a regulation of the Commission, Article 6.2, which provides for that annex, that is to define the way in which the calculations are to be made with regards to the undeclared wealth. But this was not observed. You made some calculations. You noticed that there was actually no difference, no discrepancy whatsoever. None of my relatives has a mobile asset, for instance, that would cost more than their income, but nevertheless, you did not make any reference to that. But the only ground for failing, or for the only ground for establishing that I didn't have financial integrity, that is on the basis of the law and the annex that was supposed to be the annex that we refer to in the regulation, and that is the one that is defining the way in which the calculations are to be made. Also, with regards to page 33, the circumstances that were found show the right of the candidate to a favorable decision from this point of view. I thought you would send me, as per the regulation that you've amended 4 times already, I thought you would send me already a favorable decision. However, you moved on to this ongoing cycle of re-examination. And on page 37, the panel has established, it has upheld that the circumstances that were found show that the right of the candidate, my right that is, considering a different decision of the commission other than the one that was challenged, it seems there were circumstances that could otherwise lead to the candidate passing the evaluation. The Supreme Court of Justice, that is hierarchically higher court in the Republic of Moldova, has established, in other words, that I have the right to a different decision. What is more, everything that I've stated was supposed to be taken into account in order as for me to pass the evaluation. And it is also stated by the Supreme Court of Justice, again, at my request, there was a public hearing, and the representatives of the Commission as well. And I've told the Supreme Court of Justice that the intention, the actual intention, as the councils referred to, that intention, regardless of the solution of the Supreme Court of Justice, that intention would lead ultimately to a vicious circle that the Supreme Court of Justice established, that does the evaluation following the resumption of the procedure shouldn't transform into a vicious circle, that shouldn't take that sort of appearance, which would be against the standard of effective protection of rights and separation of powers in a state and the mandatory effect of court decisions. What is more, in the next, well, a few rows below, that the evaluation was failed for some minor issues that were found by the Commission. Now, with regards to the separation of powers, to the balance of powers in a state, is something very interesting that came to my mind. In 2023, when there was the hearing at the Supreme Court of Justice, what emerged was that case, the Katan case versus Moldova, an ECHR case. It is also available in English. And what it refers to is some matters, it raises some matters regarding the sanctioning of a judge by the members of the SCM. And the court looked into the essence of that, and it analyzed how those members of the SCM were even voted into their positions, those members who then sanctioned or penalized the judge. And the court established that the members were voted into their positions by a simple majority. So the broad context, or rather the broad consensus with regards to what is provided for and what is in all the recommendations of the Venice Commission, all of that was actually disregarded, was not observed. So I would like to bring to your notice the fact that the international members and the national members were voted into their positions without a broad consensus. What is now made, this is something that the Venice Commission always brings forth in every recommendation. And the members were voted for only by one party for them to be established to those positions. And what is more, the candidate of the opposition was not voted for, not even by the opposition, for him to be in that position, in that office. So now we have a finding that the commission, even initially as it was, with that one member from the opposition, this was not voted for by the opposition. The members were voted for by one party only. So this is even worse than in the Katana case, where there was a simple majority. There was an alliance, but still there was a simple majority. In this case, we stand in the presence of a lack of alliance altogether. Also, the European Court of Human Rights established something that is very interesting, I should say, that when it came to the selection, that process of selection wasn't that clear, that not enough guarantees of independence were offered. The voting for the members, the selection of the members of the commission, these processes, regardless of whether we're speaking about the national or international members, was supposed to be based on some criteria, but there were no criteria that were known. There was no competition whatsoever. And we also have the statements of the members of the Immunities Parliamentary Committee and the MPs. They say there was a list that was provided by the donors. So what about criteria of professionalism? What about criteria of integrity?
Mr. Sandu, may I briefly interrupt you? You have nearly completed your 50 minutes, so if you can wrap up, then we can proceed. Have you finished, or you would like to wrap up? Please go ahead.
With regards to the financial integrity, I've already commented on that. I've referred to the legal framework, and I would also like to mention the appointment of the experts, the international framework, the ECHR decision as to whether there can be established there's an impartiality and independence of the members of the commission. And there was also a decision of the Constitutional Court that I referred to in my speech. And if you look at item 143, it provides for the obligation to implement the decisions of the Supreme Court of Justice and to take into account, as the obligation to take into account the findings of the Supreme Court of Justice. And I've also referred to the decision of the Supreme Court of Justice as regards financial integrity, and also referred to the law and your regulation. That is all from me for now. Thank you. Thank you, Mr. Sandu. I have a couple of clarification questions for you. And the first one has to do with a Suzuki motorcycle and the Espana model. So sorry if I'm not quite, I don't pronounce the names quite right. You've imported it in 2008. If you sold it in March 2021. In your initial evaluation, you declared that you didn't remember how much you paid to buy this motorcycle, but upon importing it, according to the customs office, the value was 5,106 lei, including the taxes that were paid. Then you sold it in 2021 for 20,000 lei, and you also submitted a contract. You did not pay any income tax, any capital gain tax. At the Supreme Court of Justice, you argued that you did not have a capital gain whatsoever following the sale of this motorcycle because you've made investments in spare parts and in the repairs related to this motorcycle. And you've also made some references to the provisions of the tax code, Article 40, paragraph 51, according to which, well, it says specifically in what case that was not supposed to be recorded as a capital gain tax. And the provisions you referred to entered into force on the 1st of January 2023. Later, however, you filed a declaration, income declaration, on the 30th of November 2023 for the year 2021, in which you yet declared the proceeds you earned from the sale of that motorcycle, and you've also reported the tax of 954 lei that you have paid. out of the declaration of the tax return you filed with the state tax service and considering the calculated taxes. On the basis of that, the Commission was not able to make calculations, was not able to establish that when calculating the taxes, the investments also were taken into account. Those investments were made into the repairs of that motorcycle. Now, in this context, we'd like to ask you to explain why at the initial evaluation you declared that you did not need to pay a capital gain tax in relation to the sale of that motorcycle.
Să răspund?
May I answer? Of course, please do. Do you want me to repeat the question? No, that is fine. I will just inform you that. And I will again refer to the law on the evaluation in 8A and B. It says two reasons or two grounds on the basis of which one can establish that one lacks integrity. And in this case, in this particular question, I don't see the reflection of these two aspects from the law, which provides for two grounds only. But I would also like to inform you about the decision of the Supreme Court of Justice on page 30, the second paragraph. Speaking of the intention to shy away from paying taxes as per the law, and this firm conviction, his firm conviction of the fact that he didn't have a capital gain in order to be able to have to pay tax. I would like to also inform you that. Give me a second, please.
Încă o dată am vrut să aduc la cunoștință intenția.
I wanted to bring up again this notion of intention. I never had the intention to hide anything away. In my annual declarations, I've always indicated the actual prices. I've never reduced them. I've never changed the prices in the agreements, in the sale and purchase agreements, as you've actually found in other cases. There are people who pass the evaluation and have made changes to the price in the contract because somebody asked them to. I did not do that. I've always put down the actual price. I've never had any intention to hide that. But upon the insistence of a number of people, I filed my tax return with the state tax authorities for 2021-2022. And what is interesting is that the ground for my failing was the fact that I failed to pay some taxes in relation to the sale of that scooter, because that's what it is, not quite a motorcycle scooter, and the value was 1,000 euros. So I would like to inform you that in the past years, my taxes were not correctly calculated. And so all of the taxes, without providing any additional documentation, the maximum taxable amount or the maximum amount of taxes that could be collected from me, the government owed me 1,080 lei, actually, the government owed to me. So in the previous years, I think you already have this, you have access to this. There were calculations that were not correctly made for taxation purposes. There was actually always a surplus, and it turned out that the government was owing me 1,080 lei. So I failed the test for not having paid some taxes, but what is more, the government was the one owing me money, not the other way around. So for all of these years, there's been always a surplus. So additionally, the way they were making those calculations, I would end up with a surplus with the government owing me the money, not the other way around. And this is something that you've also referred. And these tax returns, I've shared that with the Commission. Mr. Sandu, we've received all that and we looked into it. Well, I'm not sure if the members of the Commission know about this sale of motorcycles. Well, you state that I did not pay taxes, but given that according to my tax returns, actually the government still owes me money. Mr. Sandu, right now we would like to clarify things because these are some new facts that emerged after the initial evaluation had come to an end and after the decision of the Supreme Court of Justice was pronounced on the 1st of August. It's only after that that you went to file your tax returns with the tax authority. So the question is, what you filed for the initial evaluation and then what you filed at the Supreme Court of Justice, still, that's not quite right. Is that the conclusion or not? Because you stated that both at the time of the initial evaluation and at the Supreme Court of Justice, you stated that you were not supposed to pay taxes. And then you go and you file a tax return to pay taxes. So can you bring light around this? Well, I filed the tax return, but I didn't pay. I proved that the government is owing me money, not the other way around. But calculations were made that showed what was due for that scooter. Well, you mentioned that it's not quite right. I don't remember exactly how you stated it. Well, I understand that correctness is a matter of subjectivity, but a little correct. Is it correct or a little correct? I didn't use a little correct or not quite right. But please do answer the question, please, Mr. Sandu. What has changed from the initial evaluation and from the examination of your appeal by the Supreme Court of Justice? What happened that made you go and file the tax return and that made you report the proceeds earned out of the sale of that scooter? Well, I've already stated that I later, after that entire procedure, I went to the tax authorities to prove, to have an official document, not only my statements, to prove that I did not owe anything, that I've never had any debt to the government. And the budget of Moldova was actually owing me money. On an annual basis, they would tax me more money than I was due. So there was that balance left where the government was due to me. Just to prove that, because you seem not to trust my statement or whatever I was saying. So in one case, you evaluate the intention, in another one, the amount of the damage, but the Venice Commission, following your activity, the Venice Commission, their recommendation had to make some specifications, some clarifications that failing to pay taxes or a small mistake with paying taxes that cannot serve as grounds for failing someone. There has to be an amount calculated, and then ex officio, the Venice Commission indicated that it has to be a quantum, an amount, a particular amount, not a mere mistake. It can be a technical mistake, unintended, that anyone could commit. And then, following the practice that you've applied, and following the opinion of the Venice Commission in the vetting law, it says that it has to be more than 500,000. Your failure to indicate until before the commission even looked into that, that was a technical error then. Is that what you claim? Is that what you claim today out of your statements? Well, my position as a judge is that every year I have filed my tax returns, and there I've always indicated the actual amounts. I've never indicated the cadastral amounts. I've always put down the actual amounts, and I've never had the intention to hide anything away. And in every year, in all of my declarations starting with 2015, you can only see truthful data there. And even if you establish that, perhaps and maybe I've paid more in taxes by 1,000 more, or less taxes by 10 euros, for instance, I had harbored no intention to hide that. The commission, the lawmaker, the society are supposed to also focus on whether there was intention or not, whether the person really had the intention to hide something. But I transparently reported the information every year, and therefore this can speak of no intention of mine to hide anything. What is more, if we refer to the decision of the Supreme Court of Justice that specifically indicated in this regard that in this regard, matters like this cannot be regarded as criteria to fail the evaluation in relation to these two motorcycles. Understood. Mr. Sandu, with the Supreme Court of Justice, you've also mentioned that you did not have the obligation to pay these taxes because according to the tax code allowed not to see something as a capital gain if that vehicle has been owned for more than 3 years. But this provision entered into force on the 1st of January 2023 only. So can you tell us how does this provision apply in terms of your fiscal obligations for 2021? Well, we can find the answer to this on the page 30 of the decision of the Supreme Court of Justice. In these conditions, the special panel established that the answers in this regard did not pinpoint to the intention of the candidate to shy away from paying taxes, but actually he had the firm conviction that he did not have a capital gain to report and pay taxes for in relation to those vehicles. Page 30 of the decision of the Supreme Court of Justice. There's something similar with regards to the motorcycle Honda Hornet. That is correct. You've indicated in your annual declaration for 2015 that you imported it, you've purchased it for 25,000 lei. You sold it for 50,000 lei in 2018. You also submitted that sale and purchase agreement to the Commission. Same as with the scooter earlier, you did not report any capital gain and you did not pay any taxes in that regard. And at the initial evaluation, you've provided similar arguments, as in you had no obligation to, because you had made investments into repairing that motorcycle. And you've also submitted to the Commission information as to the price of a particular spare part and the 40 euros value, what that was for the repairs work. And then in the context of the initial evaluation, you've also written a letter to the state tax service seeking some explanations, and the state tax service responded that the tax code, the provisions of the tax code, do not establish the adjustment of the value basis for calculating capital gain, or while taking into account those investments that you make to renovate, to fix a vehicle, for instance. However, the Supreme Court of Justice, you kept referring to the fact that you didn't have the obligation to pay any taxes. Is that correct? You insisted you didn't have to pay capital gain tax. Is that correct? Well, as for the arguments, you know what they are very well. I provided them in writing. All right. Concurrently, according to the letter of the SDS of the 13th of December 2023 to the Commission, well, what it says is that as a result of the examination of the information provided in comparison to the data in the STS information system, so it was determined that you had not declared any proceeds earned from the sale of movable assets over the years 2018-2020. But we'll go back to the 2021. And according to that same letter, for 2018, you were to pay a particular amount of tax. However, because the fiscal obligation had already, the statute of limitation had already passed, you had not paid it. Is that correct? Is what I said right or not? I might have lost the train of thought as to what was correct. Well, you provided some facts. Can I answer? Can you confirm that actually you were supposed to pay the capital gain tax? However, because the statute of limitation had expired, there was the fiscal obligation wasn't there because 4 years had already passed. You did not pay the tax. Is that correct? It's not correct. When I went to the state tax authorities, I stated that I wanted to file a declaration, a state tax return for all the years, and they said it is not possible. We can go back only 4 years because according to the statute of limitations, that's what was required. Now you know what the state it is for criminal cases as well. If it has lapsed out, a procedure cannot be started. So that's why they did not undertake or not accept what I intended to do. So I did not go to file a particular tax return. I wanted to file a tax return for all the years to get rid of all of the doubts. I wanted them to look into all of my expenses and debts, to look into whether I had a balance that was positive or negative. And then they've established that it was a positive a balance, and the government was owing me money. Well, apologies for interrupting you, but just make sure we're talking about the same thing. You received that letter too, according to the STS letter of the 13th of December 2023. So it is stated that you did not report the proceeds you've earned from the sale of movable assets for 2018-2020. And therefore, the state tax authorities has established to apply repeatedly the measures requiring your compliance. and that by carrying out an individual meeting to ensure compliance in order for the funds to be reported as capital gain during the fiscal years 2018-2020. Is that correct? I mean, what the answer says, what should I say is correct or not? It's just that I'm asking just for your confirmation. Is this correct? You did have the obligation, thus, to pay the capital gain tax for 2018 and 2020. This is an answer. According to the law of Moldova, this is not an administrative act. There is an administrative code. But I would like to refer again to page 30 of the decision of the Supreme Court of Justice, which is a decision of a court, that in this we got the intention of the candidate to avoid paying taxes was not established. So that's what the court established, that I did not have the intention to avoid paying taxes. And there was a firm conviction that I did not have to pay any capital gain tax following the procedure of the sale of that motorcycle. So the Supreme Court of Justice established that I had no intention whatsoever to avoid paying taxes. It's just that I was convinced, I was certain that I didn't have capital gain to pay taxes for. And then to get rid of any doubts as regards you, the society, and the external partners. Everybody's speaking about the payment of taxes, but it was about a small value, about 20 euros, 20, 30 euros. That's what the amount was about, a minor one. For that purpose, I went to the tax authorities and I stated, let me file a tax return if you believe that I had to, because I wanted to eradicate any doubt whatsoever for all the years. And they informed me that I had to file the tax return for the last 4 years. After I did that, it turned out there was a positive balance when it comes to my taxes. As in, I paid to the government more than I was due. But in the letters from the received by the commission, there is nothing about that positive balance for 2018 or 2023. But you were talking about 2021 now, but that is a different matter. And the next thing is that actually now you're going back to, and yes, the decision of the Supreme Court of Justice, we know very well what that says. It speaks about intention, but then you've undertook a number of actions with the tax authorities, and that's what we want to comprehend.
I want to clarify just a second. You deny that for 2018 you actually should have paid. We're not speaking of the amount. If you want, you can state the precise amount, because the STS did not say what was the precise amount, but you did not pay because the statute of limitations was over. No, I would like to recap. First evaluation. You remember November, December, October, I filed many letters to the state tax service. If you remember, I was asking for information from them. Should I pay or not? How much am I supposed to pay? If you remember, all their answers were evasive. There were concrete questions, and the intent is essentially in this case. I was open to what you were invoked. I had a certain position, you had a different position. In that case, I at least tried 3 times, if I'm not mistaken, during the evaluation. I asked the state tax service about specific data. I explained the situation. Please give me an answer. And what should I do? And if you notice, I was very open with them. I told them the date, the time, the object that was sold, the price. They never gave me any indication. They were only giving some definitions as an answer. So please state once more, have I ever had the intent to not pay, to avoid payment? And also making reference to the Supreme Court decision that I had no intent, because I was filing the income tax declaration every year. I have never made any changes. I did not change any price. I filed the true information. In the same context, we would appreciate a clarification about the car Skoda Superb that you purchased in 2017, right? I think it was 2017. It was summertime. You declared that car during 2017 to 2020. Do you remember how much did you pay for it? No, I don't. Now you're asking me, and I remember it relatively. I will make a mistake, and that's why I don't want to make a statement about that. I just want to tell you that the sale of that car was not object to my initial evaluation. It was not underlying my candidacy in first evaluation. And when it comes to the tax paid, I filed because they asked me to submit ownership documents. I did not have them, and I told the customs service, set the maximum without deductions. You know, from the value of a good, you have to deduct the purchase price. I did not have any documents proving origin because that was long ago, and I asked them to set the maximum amount I could pay to clarify, not to have any discussions, not the pre-vetting commission. I did not do that for the pre-vetting commission. I did it for the general public, for anyone, for any independent observer, not to have any doubt. And they said the maximum amount I could have paid. Well, in reality, I should have paid much less, but I only wanted to clarify that matter. Mr. Sandu, you remember very well that during the initial evaluation, you received the questions about the commission on this topic. No, it wasn't. It wasn't the subject. Yes, that's why we try to clarify, because the information, you saw that we received this information only now in April, and according to the information that you submitted to the commission, you purchased that car with 6,000 euros and you sold it for 120 lei, which was around 6,000 euros also. At the same time, on 2nd of January, you submitted an income declaration for 2020. I understand you filed that declaration as a result of a voluntary meeting you had with the state tax service in December. So in that declaration, you mentioned the sale of a car, and the state tax service established that you had to pay 2,849 lei as income gain tax, as capital gain tax, and a penalty of 1,022 lei. Can you tell us why and how did they establish that? I don't know how. I don't know their formulas for calculation. They imposed that. Moreover, I had an overpayment of taxes, and then I got a certificate that I have zero MDL debt for all the years. I don't owe a penny to the state tax service. Sorry. When it comes to the questions about this, I think this is unfounded because this was not subject to the first evaluation. In your decision to fail me, this wasn't invoked, and according to the decision of the Supreme Court and according to the Constitutional Court, you cannot refer to that because this turns into a vicious circle, and it is a unfair attitude towards me compared to other candidates. Moreover, I can, if you allow me, I can say that you passed two candidates, both judges and prosecutors, and after that, there was a lot of information in the public area. And you were informed by the anti-corruption prosecutor's office, and you did not revise your decision. But in my case, if you had doubts about my integrity, but for my resumed evaluation, so sorry, I can't. So we are making a revaluation based on the resolution part of the Supreme Court. We are not making this reevaluation from the top of our head. We do it as... Sorry, I couldn't hear you.
I think there's a slight technical issue. Yeah. Is everything in good shape again?
I was said 2 minutes. I couldn't hear anything. Should I leave or should I stay?
I don't think so. I think let's briefly wait for 2 minutes and then let's continue.
We are ready to resume, Mr. Chairman.
Are we ready to go on?
Yes.
Okay, let's move on then. Sorry for the interruption then. Nadesia, please go ahead. Yeah.
Bine, eu doar făceam precizarea că
I was
în
only
cazul domnului Sandu,
clarifying that in case of
reevaluarea
Mr.
se face de
Sandu,
către comisie
the
în
resumed
baza
evaluation is done by
deciziei
the Commission based
Curții
on
Supreme de
the
Justiție
decision of the
și în
Supreme
baza
Court of
prevederi
Justice
expres
and
prevăzute de
based
lege. Nu este
on the
inițiativa
reasons
comisiei.
expressly provided in the law. It's not the initiative of
Ca
a commission to do that.
Doar
Well,
să facem un rezumat al
to try to
întrebării precedente.
summarize the
Puteți
previous
să
question,
confirmați, ne ajutați
could you
să
please
înțelegem?
confirm, help us
De
understand,
fapt, acest impozit dumneavoastră l-ați
this
plătit
tax,
după
you paid it
evaluare,
after
după
the
ce
evaluation,
cazul dumneavoastră a fost
after
examinat și
your
de
case
către
was
comisia
examined
la evaluare inițială și
by
de
the
către
Commission during the
Curtea
initial
Supremă de
evaluation
Justiție.
and by the
Și
Supreme Court of
nici la
Justice.
evaluarea
And
inițială, nici în fața Curții Supreme de
neither
Justiție, dumneavoastră
during the
n-ați
initial evaluation nor
prezentat
before the Supreme
informații cu
Court,
privire la faptul că
you
ați
presented
datorat
information
ceva,
about the fact that you owed something,
impozite de achitare pentru
some taxes
realizarea acestui autovehicul în anul
for the
2020.
sale of this car in 2020. Correct? I don't owe, and I have never owed to anyone. I don't owe anything. If you notice, I have never had debts to anyone. I don't owe anything. I have always been transparent. And again, I'd like to inform you this matter related to the payment of alleged taxes was clarified by the Supreme Court. I provided you a certificate from a state tax service during the initial evaluation that I have no debts to them. Moreover, in my work, I have never been a subject of investigation by any institution, either local or national level. Neither it wasn't the state tax service or any other administrative institution. What else can I say? The Supreme Court stated expressly that in relation to the payment of taxes, there are no doubts related to my financial integrity, neither regarding the amount nor regarding their effect. Currently, in 2023 or 2024 in January, after I talked to the representatives of the state tax service, I voluntarily said, please assess as much as possible. I want you to give me a certificate that I have zero debt. And I have never received a report that I have debt towards the state tax service or any other institution of communal local level. I have never had any debts, and if I knew that I was owing something, believe me, I would have paid any possible debt from my very first salary, because this is a very small one. For a public dignitary, 20 euros, 30 euros is not a burden to hide or not to pay. Thank you, Mr. Sandu. Let's move to the next issue, the import of those 20 vehicles in 2009. They were imported according to the data the Commission collected during the initial evaluation from Italy and Germany. All of them were registered in your name with a total value of 522,778 lei. You declared during the initial evaluation that the beneficiary or the de facto beneficiary owner of the vehicles is a former relative of yours, a former close relative, let's call him JP, and you were helping him in a business he had related to sale and repair of motorcycle and cars. You did not have the contract for the 20 vehicles, and you stated that they were all sold by means of power of attorney. According to a statement of your former close relative, all this work, registration of vehicles, you did without being paid. So you got no payment from him. So neither you nor him provided any evidence on the ownership right of this relative with respect to any of the vehicles. And during the resumed evaluation, the Commission collected new data confirming that neither you nor your relative declared and paid any capital gain tax in relation to the sale of any of these vehicles. So we have some clarification questions on this issue. During the initial evaluation, you submitted a written statement of Mr. GP, where he declared that he confirmed that all means of transport imported in 2009 in your name actually belong to him, and that you helped him during the import and transportation. And you did not obtain any income from the sale of those vehicles. Before the Supreme Court, you submitted another statement of Mr. GP, where he stated that all these vehicles imported in 2009, and here, please pay attention, he mentioned in brackets all motorcycle and the BMW car were imported in your name, but they actually belong to him. He also said that you helped him only with the import, customs clearance, but in case of a BMW, you helped him with transportation of a car as well. Again, he mentioned you did not earn any income from the sale of these vehicles. He stated specifically that the Suzuki motorcycle make year 2007 and the Honda Varadero make year manufacturing year 2004 imported in 2010 also belong to him. Could you please explain in the list of the 20 vehicles, this is table number 2, that's why it was provided to you today in the statement of doubt. So it lists not only motorcycles, but also 2 cars, one BMW and a Volkswagen Polo manufactured 2009 that was damaged. Who was the owner of that car? Let's clarify about the BMW. I explained from very beginning in any procedure. There was a confusion. Why? When you made the translation, no, we're not asking about the BMW. No, but I want to tell you, there was a general confusion about that vehicle in the translation for that address. In one part of the text, it was said motor vehicles. In other text, it was called vehicles. In other part, it was motorcycles. That's why there was a confusion, both I had and my relative, probably the general public also. Can we make a clarification? Some of them were motorcycles and 2 cars. 18 motorcycles, 2 cars. It's clear with the BMW. Who did the Volkswagen belong to? You raised a doubt about my statement that was filed for the first time in the first round of questions. You asked me about the motor vehicles, 20 motor vehicles, and I answered you. They were not listed. I, as people in Moldova, do have a right to travel, and there was an import of motor vehicles at the request of my relatives. And I imported the BMW, but it never belonged to me. It always belonged to the family of Mr. Georgiev, who was my brother-in-law. So it belonged to my sister's family. About the Volkswagen Polo, if you remember, in the first hearing, I mentioned that the car that I held and my family, because my father was working abroad, so I was living with my mother sometime, because my mother was also living some periods of time. We're not talking about the car in 2001. We're talking about from 2009. I want to tell you the Volkswagen Polo. We had first one Volkswagen Polo, then we had another Volkswagen Polo in the family. After we sold the older one, we also got a Volkswagen Polo. We did not buy luxury cars. It was Volkswagen Polo 2001, then a Volkswagen Polo made in 2009, and then we had a Peugeot 307. These are cars belong to the family. So you have it in the table. But the one in 2001, I'm not sure it's in this table. The one from 2001 is there. That is clear. The question is, who did the one made in 2009 belong to? It belonged to the family. Look, the delimitation. Who does it belong to? My family. What does that mean? It was my mother, father, and I, because my sister had a different family at that time. So it belonged to the family. But the right of ownership. But whose money did you use to buy it? My father's money. Family money. Why during the initial evaluation you mentioned it that they all these 20 were purchased from money of your brother-in-law? Wait, no, you did not make a clear delimitation of what means of transport you are talking about. You just, I don't know how many they were. I explained what the procedure was. It wasn't my intent. There were they 19 or 21? What belonged to my family? You can check the insurance policies. They're drafted in my mother's name and in my name. Please ask the database with insurance policies and see what insurance policies are in my name. Those ones were represented by my, they were for my family, and they included my mother's name too. Because until last year, for insurance to be valid, you should have mentioned expressly the person that was driving. I don't know if you are aware of that. I know. In 2008, 2009, for an insurance to be valid, you needed to include in the insurance every person that is driving. So check in the insurance where you see my name and my mother's name because she's driving since the 2000s. That is good property as that belongs to my family. So I want to clarify one thing if you don't have any more questions here. I have questions, but clarify. No, ask your question. So what about the two motorcycles that the gentleman highlighted? During the initial evaluation, he didn't say anything about them. Was there anything special about them? Ask him. I don't talk to him. But it was you who provided both statements. He gave it to me. I told him that you failed me. I gave it to him and I told him, please clarify, explain how things were. And I think that in your failure decision, you wrote some things and he answered to that. Ask him. We are not in hostile relationships, but still, it's not family relation either. As you know, the commission sent Mr. GP the list of 27 vehicles that were purchased in the years 2011, sorry, 2008 to 2011, all registered in your name, and we asked him to clarify which belonged to him. He answered after we sent the statement of doubts, statement of facts and serious doubts, and he explained what you were saying, which belonged to him. So all the motorcycles were his, except for two ones that were purchased by you after 2011. And again, he confirmed that you did not earn income from that. At the same time, he confirmed that all of them were not purchased or imported. All these vehicles were not imported through his company as a legal entity. Could you please explain? It's a list, it's a quite extensive list of means of transport, and you registered them all, and then you helped him with the transport. What was the economic rationale of providing all of these services for free to this gentleman? I did not provide services. What did you do? You say providing services. I told you we were in a family relationship. In a family relationship, you don't provide services. Maybe in some families they do, but I want to go back to this clarification. First thing, when it comes to, you said that he gave an answer after I received the first, what's the name of it? Yeah, the statement of facts. Because in your notification, you said that when contacted, he did not answer. It said, so I contacted him and said, a request was sent to you. Why didn't you answer? Is there a problem? And he said, no, he did not receive any request from you. And later, I think he was even called, and Ms. Prokhnitsky talked to him. Yes, an email, and the email address was wrong, and it was sent once more. Yeah, we clarified things. So I found out about that later on from your decision, where you mentioned that he did not answer. If something is not clear, you can ask him, but I will go back to the legal aspect here. After you issued the decision, if you don't remember, I will remind you. Before it was published, the news already knew the solution. The news, media outlets. And you probably know, first there were news and then the decision was issued. Moreover, there was a TV program where they said that I had businesses and vehicles and I'm a judge. So let's inform the general public and the foreign partners. What was invoked is coming back from 2008, 2009, when I was a student, my third and second year at university. Neither me nor my relatives nor my parents held any civil service positions in Moldova. There were no obligations to declare, and there are no doubts about the origin of the money. Both my parents and my former brother-in-law have worked for a long time outside the country in order to gather some financial capital. And now I would like to inform you that according to declaration in the interview made by Mr. Hebel, who said that judges who have assets that cannot prove, neither me nor my relatives, not just close family, but relatives of second, third degree, none of us have been civil servants before. And moreover, according to Article 3 of Law 26, and we say that candidate meets the financial integrity criterion if the assets was declared in line with the legal regime. That's true for me. Or if the commission finds that the assets acquired by the candidate in the last 15 years corresponds to the declared revenues. So now let's talk about property of myself and my family in the last 15 years. 15 years ago, I was a student. I did not hold any position. My father, speaking of the last country, he works in there since 1999. He had legal income, which were much, much bigger than the assets belonging to my family and my relatives. Going back to the legality of ownership rights for these means of transport, I would like to inform you that it wasn't found, and it cannot be found that an illegality in ownership rights over these means of transport. All of it was done legally, and all taxes were paid, all fees were paid. As you said, over 130,000 lei in customs duties were paid. So the duties, taxes provided for by the legislation of Moldova were paid, regardless of the fact whether they were registered in my name or name of my relatives. All legal duties were paid. And what I said before about their sale, I was not involved in that. I passed the ownership right by power of attorney, what is provided for by the legislation of Moldova, and I have not violated any legal provision, and no civil law, administrative code, or criminal code provision. Everything was done within legal boundaries. I have a right as a citizen of Moldova to transfer my possession right by power of attorney, and all ownership rights. I can transfer them by power of attorney. I did that. And And I would like to tell you that no person in Moldova, it's not only me, but nobody in Moldova in 2008, 2009 had the intent to hide anything. The sale was not done by contract, not because people wanted to hide something. That just was a practice. So if you don't know, ask your relatives when when you bought something, a vehicle at the car market, there wasn't even a documentation center. There was a notary who was making the transfer of rights by power of attorney. And that cannot be invoked to me because this was not done in the context of my job duties. I was a student then. I was investigated by the Security and Intelligence Service. When I was appointed, I provided documents from my personal file that is kept with the SCM. The Security and Intelligence Service analyzed this. Moreover, all institutions, starting with the Office of the Prosecutor General, State Tax Service, they all gave a positive endorsement. And that was in 2014. It started in 2014, and in 2015, I started to work. So that control inspection took place in 2014 and early 2015. Subsequently, I was invited to the president of the country, Mr. Timofey, who was a judge. So I was invited to a meeting with him and with representatives of all law enforcement bodies, with representatives of the SCM, of the parliament, with everyone, where they discussed my candidacy, and all documents were presented about ownership right of me and my family. A lot of questions were asked, and the president of the country is a resigned judge. And he did not have any doubts about my integrity, and he appointed me a judge. So what you are mentioning now had been examined by all authorities back in 2014 and 2015, and by the person who was the president of the country. Subsequently, I will not tell what the year was. I was granted access to level 1 state secrecy. To be granted this level 1 state secrecy, I don't know if you know about the ranking, degrees, hierarchy.
And for that, I had to be subject to an investigation controlled by all state institutions, and in all perspective, not only from the perspective of financial integrity, but also considering the risks to national security if I had access, the access that I was granted. And working as a judge, that had also who was also an investigating judge, I had access to, and I've also examined cases that the state intelligence service has never even, after examining those cases, they've never even stated that there were any cases or attempts of corruption on my behalf. So the matters that you're raising now, looking back at when I was a student back in 2008, 2009, that it was looked into not only once in 2015, but it was also looked into twice more in other years when I was then granted that clearance. And what is more, I've also been subject to continuous control practically, and nobody has ever found any doubts with regards to myself. However, and now some reference was made to certain actions that were undertaken that, first of all, cannot be imputed to myself as a candidate, as a civil servant, high-ranking civil servant, because that had nothing to do with my professional activity. It all happened when I was a student, and I have not violated not one piece of law, no provision of the civil code, because the civil code doesn't provide owning property. There is no provision of the civil code prohibiting transferring over certain rights by means of power of attorney. And as for the origin, and as for the assets themselves, there was never any doubt whatsoever with regards to the origin of those assets. I have not committed anything illegal. I've acted in line with the law of Moldova. I've not violated international law as well. Thank you, Mr. Sandu. Between 2008 and 2015, you've imported in your name 11 vehicles, means of transport. It is perhaps important to mention that in that period of time also covers a period of time that you've been a student at the National Institute of Justice. Now, with regards to these 11 vehicles, when I was in the institute, are you saying? So 2008 to 2015. And at the NIJ, you've been a trainee between 2012 and 2014. Is that correct? And so which one of them were bought while I was with the NIJ? You can have a look at the table number 3. That's where these are indicated. The question is rather general, but just to clarify certain things. Out of the 11 vehicles, the Commission has information on the Toyota Corolla that has been clarified, and the doubts have been clarified already, but I would like to make a particular focus in this regard. And there was the Honda Hornet. With regards to the rest of the vehicles and the 20 ones that have been previously imported, with regards to these, it wasn't possible for the Commission to look into. The Commission did not receive any information from the State Tax Service to confirm that you or your relative paid any taxes whatsoever related to the sale of those vehicles. Can you confirm, if we add them up together, it's 31 vehicles, all of them registered in your name? And out of them, with regards to one only, at a later time, the tax was paid, the capital gain tax was paid. Only with regards to them, and for all of the rest, no capital gain tax was paid. Is that correct? There was no capital gain tax. There was no. You are now referring to a period when I was a student at the NIJ. While I was there, you've indicated that we have to be correct, only one car. In 2014, one car only. But at the time, I had already graduated from the NIJ. While I was a trainee at the NIJ, there was no registration of vehicles in my name. As regards and going back to what was it that you meant that the relative hadn't paid? Look, we're all adults. If you have any doubts with regards to his work, he's not my relative. No, my family. No, my question. Sorry, my question to you is, I guess you've already analyzed this. Still, for all of these other vehicles, was there capital gain or not, or you don't know? What is your position? Look, let's make a delimitation between income tax or capital gain. Capital gain tax. So capital gain tax, not an income tax, but it's a capital gain tax we're talking about. I did not have access to, I did not obtain or have any capital gain. I am not aware. More than that, there is a decision of the Supreme Court of Justice. I will tell you what page that is on. It stated that with regards to vehicles for 2008-2015, the obligation to pay taxes, capital gain tax, out of the sale of those cars in 2008-2015. So the panel believes that that was unjustified on behalf of, as far as the Commission is concerned. With regards to the Corolla, well, that is clarified. You've already provided an evaluation report that you did not submit previously for the initial evaluation, so that has been clarified. It's just that around the Corolla, when it comes to that, you did not show me, you did not make any notice regarding the price. I mean, just referred to, but in the materials of the evaluation before the hearing and after that, it has not been submitted to me. Only when the decision came along, that's when I was given some report from a website that had no name for a car that was slightly different, and the engine part as well. And then, what is it that you were after? If you ask me about that car, I've told you about it at the hearing, but that was not in the materials of the case. So that was purposely made to catch me in a trap. That is a totally different car that was referred to. We're the different carriage body altogether. But in your answer to the notification on facts and serious doubts, there was a question regarding the profit and the proceeds earned out of the sale of all of these vehicles. You stated, you've actually mentioned the income of your father in Spain, and you somehow stated that the Commission was to look into all of that information from the bank. Can you tell us what is the relevance of that now in the context of the 2015 matter? Well, I can provide an answer as to that. I've looked at different TV shows that you participated in, as well as the foreign experts, that the Commission works very well together with institutions from other countries. So then I've asked you to cast away any doubt with regards to the income of my family. I told you that you could seek that information from those institutions. I even told you what the country was where my father has been working officially since 1999. So I told you that so that you could look up into the income of my father for that period of time. Because you, I think, Victoria, actually asked me at the initial evaluation, asked me about the money that was used to support me as a student. What is the money that I lived off when I was a student? And it was not only that, but later, at the Supreme Court of Justice, by the third attempt, the third panel put on you the obligation to submit that report. And then my opinion, because there's been such a report drafted by the NAC with regards to myself as high-ranking civil servant. And the wording that they opted for was very interesting. They've looked into the assets of my family. They've established that my father was traveling abroad, and they had a list of all of those times he went out and back to the country, but then established that he was not living in Moldova. And he stated that the assets of the family, the value of the assets of the family exceed the income earned on the territory of Moldova. So they wanted to be on the safe side. They stated that it exceeds the income earned on the territory of Moldova. In my declarations in our communication, I've stated that my father does not own any property, not a movable one or an immovable one in Spain. He's only been working there as an engineer, an international company. If I'm not mistaken, it is actually based in the Netherlands. And he's only worked there as an engineer, an electrical engineer. He was traveling. You could see he would travel to Moldova at least 3 times a year, on Easter holidays, on his annual summer leave, and then on winter holidays. And according to the law in force, according to the national and international European law, declaring amounts, you're not required to declare less than 10,000 when you cross the border with the customs authorities. So that's why I've raised that issue, and I showed you statements, the bank statements, and you could see that there were being amounts are being accumulated, and a day or two before he traveled to Moldova, he would extract the money, he would withdraw big amounts of money from his accounts just a few days before traveling to Moldova. And the fact that it couldn't be proved that the money has been brought to Moldova by my father. Now making that statement would be just saying that when a person takes money out from an ATM machine, you can't be certain that that person took the money or managed to take all the money home from the ATM, for instance. And I think this is an offensive statement to make with regards to a person who's been working earnestly, because he didn't go there for wanting that out of personal reasons, but there was a financial need that made him go abroad, and the need to support the family to work abroad, not in order to acquire goods and assets abroad like a house or a car, but to invest everything back in Moldova. And I would like to inform the general public, the European community as well, that my family only owns one house in the suburb back in 1990 something, and we moved into it in 1999. And it only owns an apartment, a one-room apartment, a flat that my parents have privatized. They had a they privatized, sold it, and bought an apartment in a new building. So these are the assets of my family. And as for hidden properties, you've looked into all of my relatives, of my family. We have nothing else. This is all the property that my family owns, that my relatives own, and honest work has been done to obtain this, and taxes have been paid. Thank you. Now, moving on to the next issue with regards to the 6 vehicles that were imported in 2019 and that were registered in the name of your mother. Total value is 1,679,202 lei. So all of these vehicles were registered with the Public Services Agency, PSA. If I may, the value that you stated is the value that was established by the customs inspectors. That is not correct. I showed you documentation. That is not the right amount. That is, it's either twice or thrice the actual amount. And all of these vehicles were then sold between 2019 and 2022. At the initial evaluation, when you were asked about the quite considerable difference between the value of these vehicles as set by the customs and the sale price for such vehicles, for these vehicles in Moldova, when you were asked about the difference, you've practically anticipated it now, and you've already stated what you just said, that the customs officers had purposefully increased the value of those vehicles in order to be able to collect higher amounts of taxes, of duties. And similarly, during the initial evaluation, apologies, it's not for to increase the value of the taxes, but I mean duties. What is to increase the value of the commodities imported into the countries, because on an annual basis, they were supposed to report on what is the amount of commodities imported into the country. And also during the initial evaluation, you've told the Commission that those 6 vehicles were actually purchased in 2018 in the United States by a family friend. You've also provided that statement, a statement made by that person. And it was stated that your mother was proposed to buy a car for herself in exchange for certain services, and specifically in order for her to deal with all the importation procedures for all of the 6 vehicles. Now, the Supreme Court of Justice did not address the 6 vehicles. During the resumed evaluation, the Commission collected additional information from the Public Services Agency, and according to that additional information, the Commission actually received those sales and purchase agreements that had been signed in 2018 by your mother, and out of the 6 vehicles, 5 were sold. For 3 of them, there was that technical report showing there was no technical issue with the car, that the car was not damaged. That is not correct. You don't have the right information. What 3 technical reports are you talking about? So technical, for 3 out of the 6 cars, there were these technical reports. The report was drafted not for addressing the integrity of the cars, but it was for Interpol purposes. Now, according to the information from the Public Services Agency and from the Customs Service regarding these agreements, now that contradicts somewhat what your friend has submitted to the Commission during the initial evaluation, and specifically that at the time in his initial statement that he presented, that you submitted to us actually, he stated that he'd come to Moldova in 2019, but he told you about the 6 cars, the 6 vehicles, and he had reached that agreement with your mother for her to buy one of the cars at the auction price and for all the rest to be imported in her name, under her name. According to that statement, your mother, until 2019, was unaware of those vehicles, of those 6 vehicles. She's found out about them when your friend came to Moldova. Concurrently, the agreements had been signed by her in 2018. After the statement of facts and serious doubts was sent to you on the 29th of March 2024, your friend wrote to the Commission and submitted the following explanations: that in 2018 he had purchased those means of transport through the company Northwest Motors LLC, and that the agreements, the sale and purchase agreements, had initially been signed by him under his name. But in 2019, when he had decided to export those vehicles to Moldova, he realized that for all the clearance procedures, customs clearance procedures, that it would be hard for him to move on with those agreements signed by him. So that's why he went to that company in order to make amendments to the agreements and have the name of your mother introduced there, and that company had destroyed the initial agreements, but that the date remained the same on the agreements at the request of that company in order to stay consistent internally in terms of its internal documentation. So he recommended us to get in touch with that company. It's a company based in the US. Yet again, this information is somewhat different from the information that your friend submitted to the Commission in February 2024, when he had stated that he had personally made the payments for each of those vehicles, not that it was not via that company. But how did he pay? What didn't he pay that personally? I mean, and he initially said that he paid, and then he said that he's purchased all those vehicles via the other company. But the payment took place. Yes, the payment took place. Now, the Commission tried to look into the information that your friend stipulated with regards to those companies, the companies that he specifically named. So we tried to look into that as regards that procurement of the 6 vehicles in 2018. So there was IAA Holdings LLC and Northwest Motors LLC. According to the documentation that the Commission received from the Public Services Agency, all those agreements, the bill of sale or purchase orders, as they're called in English, for 5 of those 6 vehicles. Now, specifically speaking about Northwest Motors, and there is one where reliable car sales is concerned. So you already know of these data. This is all in the documentation that the Commission has shared with you. All the information as to who is the owner, what the address is, all the information there is identical for in all of the 6 documents, and even there is even a typo that is the same in all of the documents. Both of these companies are registered as limited liability companies in Oregon. The first was established in 2008 and the other one in 2018. And we were able to learn more about people who were registered as agents that were responsible for these cars, including a person who had been convicted multiple times. Can you say that again? Convicted for what, if I may know? For identity theft during electoral campaigns. And you are aware of this information. The Commission has shared this with you. And as for the address, the post address for both companies, that address is the same. It is identical. At the same time, both companies seem to actually to go through a dissolution process. The first one filed for this process on the 14th of March 2019, and the other one on the 22nd of March 2024. All of these vehicles, the 6 vehicles that were purchased and registered under the name of your mother, they were registered as lost in the state of Washington by insurance companies. Lost. Like total losses. I might not have interpreted it properly. They were off the books of the company. They were taken off the books of the company. That's what was meant. And all of these vehicles, all these cars were sent from the United States of America on one and the same day. Now, the Commission tried to call and try to get in touch with these companies. Now, none of these picked up the phone, although voice messages had also been left. Now, on this entire background, could you tell us when is it that your mother signed the sale and purchase agreements for these 6 vehicles? Look, both the family friend and my mother, they are adult people. And whatever questions you'd like to ask them, please do ask them. As for that family friend, he's been here for about 3 weeks, and he left last week, and he wanted to participate, actually. He really wanted to participate and provide his opinion on what you mentioned, that the person, that company that he bought the cars from, that the companies have gone bankrupt, and there was some convictions. I mean, it's like a soap opera, everything that is happening. If my mother and my friend went to the supermarket and they buy something, and then it turns out that the owner of the supermarket is under some investigation, what does that have to do with my family and my friend? Now let's go back to our evaluation. But Mr. Sandu, well, not to allow for also all sorts of interpretation, all this soap opera began from the declarations, the statements presented to the Commission by you and your friend. You were simply asked about when the agreements were signed and what were they sold for in Moldova, and why was it much smaller than the amount the cars were bought for? So it was very simple. Well, but I've already provided an answer, but you didn't want to hear me. I've already indicated that all the cars were bought at an auction in the US. Madam Victoria is a citizen of the US, and she can very simply look things up online about how these auctions and procurements are carried out. It is all happening online. I've already informed you that these are public auctions. You can just write, you can Google it. You can Google the VIN code of every car, that is that registration number, the 13 digits. If you could put this down in Google, you will see all of the information, pictures of that car, the date it was sold on, the price it was sold for, the fact that the customs service is tripling the amounts. Now let's clarify this. When were the agreements signed by your mother? Look, let me continue my train of thought. You've mentioned something about the Supreme Court. I would like to inform you that in your decision failing me, in that decision, the fact that these assets of my friend and of my mother, they were not mentioned as a ground. Well, they were encompassed in the first decision. No, you are not right. You're not right. They were not mentioned. Let me go to that. Mr. Sandu, let me continue my speech. Nadezhda, let's have respect. You are launching some accusations, but you're not letting me respond to that. I will look back at this decision whereby I was failed by you. And when it came to failure on the basis of the financial issues, financial grounds, the car of my friend or of my mother is not referred to. There are only 3 criteria: 2 motorcycles and the taxes related to that. And then the movable assets in 2008 when I was still a student, and that was of my relative. And then the payment of taxes for 2008-2015. So 3 criteria only. So the Supreme Court cannot, if you remember, according to the law of Moldova, the Supreme Court only operates within the limit of what is being examined. No court of Moldova can go beyond those limits. So as long as your decision only refers to 3 aspects, they've only commented on that. It's not like they've ignored. It's not like they didn't want to address other matters, but those were not grounds for rejecting me, for not passing me. So it would be incorrect. It is incorrect, rather. It is incorrect for you to raise these now in a resumed evaluation, in a vicious cycle where you are trying to grab for something additional only to fail me. All right, fail me, but let me continue my idea. However, don't just go on this vicious circle and make all of these descriptions that are impossible. My family and my family friend is a person of means and funds. His funds were acquired legally. And my mother, too, is a person who's worked for a lifetime, and she, too, has money, and she can prove where that came from. We provided statements of the bank accounts, and you can see the deposits of my parents, of my mother, of my father, what they've earned for their advanced age because they've already retired. These are assets that they've earned before I became a judge, when I was still a student. These are assets that my parents were able to pay for thanks to earnings for during their lifetime, legally obtained. Now, if you have any questions with regards to the income of my parents or of my family friend, you should raise those questions with them. If you have any doubts, then go to law enforcement bodies to raise this. But don't ask me and then make these claims and then referring to a person who I don't even know who that is. In 2018, 2019, I haven't been to the US. And are you telling me that there's a person who is convicted for identity theft in 2016 when Trump won the elections, that he's been involved with that? I mean, what do I have to do with that? There was a statement made on the 15th of May in your report that I refer to. Now, going again back to that, you're carrying out the evaluation on the basis of law number 26. So on the basis of that, there are two grounds for integrity, financial integrity. The assets was declared in line with law is one of them. For all the years when I was in civil service, in public office, I've always declared I've never violated the regime of declaration, the deadline, and I've always declared all the assets. I've never made any rectification to my declarations throughout these years, and I've never reduced the price of anything. I've always been writing things the way they were, in opposition to candidates that you've passed who've recognized to reducing the prices. And I've never had the intention to hide any asset or to avoid paying taxes. I've always observed my duties. And the commission established that the assets obtained by the candidate over the last 15 years corresponds to the declared income. And I've given you the possibility, and you looked not only into my situation, but into the situation of my relatives. None of my relatives has no movable or removable asset that would exceed their income. And I'm speaking not only of the first degree relatives, but level 2 or second degree, third degree relatives as well. None of them has assets that exceed their income. But now it's like you're looking for reasons and ways to motivate, to support your decision that you've already made. That's what I wanted to say. And in this regard, I had nothing to do with Trump's elections back then, not in 2020, not in 2024. So I don't want to be imputed anything in any matter, any affairs that I have no knowledge of, Mr. Sandu. All of this information was collected on the basis of the very vague information that makes no sense, that was presented by your friend, that brings no clarity at all with regards to the history of this cause. So please answer two simple questions. If you know, if you don't, you just move on.
Let me explain you. You are saying did you help your mother to draft a contract, or does she speak English and she drafted all those contracts on herself? On her own. I want to tell you some things. First of all, speaking of vague statements and declarations, I don't know what they provided. Maybe you had some additional communication. Maybe you talked on the phone. I was not deciding what evidence is submitted and what you believe to be vague. I thought when I submitted them, I thought they were good enough. You just tell me what you need and I will. So the only decision which under resumed evaluation had a positive evaluation was motivated by pictures and videos. So tell me about that and I will provide you pictures and videos. If you think that's appropriate evidence, I will do. Moreover, I ask you, let's look in all relatives. Tell me what evidence you need and I will. The only decision that succeeded to have positive decision was based on pictures and videos, and tell me what's that this is the degree of proof in such a procedure. Tell me, because I have pictures and videos from 2008, 2009. I did not document it, but I filmed some matters of my life. Mr. Sandu, could you please answer my question about documents? I did not help anyone, not my family friend, not my mother. They are grown-ups. They all have higher education. They had administrative jobs or managerial jobs where they work. My mother is very active socially and from a public point of view. She's driving a car since 2000, and she got a driver's license since I was a minor. I was still going to school. in secondary, lower secondary school. Everyone in my family is a personality, but it's only me who's in the civil service. But all my family members, they are all personalities that are remarkable in the field that they work. And according to international principles and the Soviet Union principles, everyone is accountable for their own actions, not for their relatives' actions. Mr. Sandu, about the contract, do you know when it was signed? You don't, from what I understood, but I did not it wasn't part of it. I did not sign. If you want, I can could go dactylography, graphology, I think, review to make sure that I did not sign. Do you need a 5 minutes break, or can we continue?
Thank you,
No.
Mr. Chair. I have no more questions to this issue. Issue number 2.
Anyone else who has any questions in relation to issue 1, or are we able to move on to issue 2? Yeah, shall we go on to move? Then issue 2, Mr. Sandu, relates to the transaction involving the Mercedes E220 CDI. As was included in the statement of facts and serious doubts, we formulated our doubts as following. In relation to this issue, the Commission has serious doubts about the transaction between IC, your friend, and NB, a prosecutor appearing before you in judicial proceedings, in that it appears to have been only a means for you to buy the car and thus conceal a financial transaction between you as a judge and a prosecutor appearing before you. This transaction amounts to a breach of ethical standards, specifically the requirement that a judge refrain from any financial transactions that involve him in agreements with lawyers or other persons who are participants in trials in the court in which he operates, as well as the failure to ensure that his or her conduct is above a reproach in the view of a reasonable observer, and reaffirms the people's faith in the integrity of the judiciary. That was the serious doubts as we formulated it to you. If you now wish, please briefly provide additional explanations to complement your written responses to the statement of facts and serious doubts. And as we indicated before, you will be provided a maximum of 50 minutes. But of course, you don't have to use all 50 minutes. But if you would like, please go ahead, and the 50 minutes start now. Please go ahead, Mr. Sandu.
So I will first speak of a legal framework and then factual framework. I would like to inform you that based on the decision of the Supreme Court, it's stated clearly in terms of ethical integrity that violations held by the Evaluation Commission do not meet the criterion of deciding on candidates' violations of high severity. They cannot be considered that they exist. Generally, they cannot be considered as existing, and the Commission did not motivate what was the high severity level about. So the Supreme Court said they cannot be considered as existing. Your doubt. About the decision of a constitutional court, also with respect to my notification, the constitutional filed by me, the constitutional court said that the one who applies Article 8, paragraph 2a, it may analyze. If needed, I can give you the... Let me read article number 8, paragraph 2, letter A. Did not violate the rules of ethics. So who applies that article can apply it in corroboration with provisions of Article 4 prime from the law on disciplinary liability of judges, which is common right for all candidates for the SCM. So in order to find a violation under law 26 for paragraph 2a, you need to make reference in collaboration with Article 4 prime or 6 of the law on liability of judges. So I also prepared an abstract from that law, and I didn't see in the articles mentioned by the Constitutional Court, I didn't find any request. If you can invoke them, please tell me so that I could defend myself. What point from here is applicable, because there are so many of them. So with respect to the car, generally, this is a matter that will, well, one day we will find out the truth. First of all, about Commission's allegation that EC is a NAC officer. I looked into all the materials, and there was no indication that EC would be a NAC officer. But in the first and second round of questions, the Secretariat mentioned that I purchased from a NAC officer. It's really doubtful. How could the Secretariat find two people who have the same name but have different ID number? How could they mix them up? This proves once more that it was an intent, a criminal intent, I would say, to draw a connection, to cast a doubt on my integrity, and connect me to prosecutors, NAC officers, and so on. Then the biggest doubt was about the answer, both of the Commission and of the National Commission for the Financial Market, about an insurance, if you remember. One day before the hearing, I managed to find that I had two opposite answers from the same institution, which said that there was an insurance on my name on behalf of a prosecutor. Then I had another answer which said that no insurance was drafted, only uploaded to the program. So someone before the evaluation in May 2021, I have some supposition who did that, framed all these actions. They drafted an insurance in my name by made a prosecutor. Well, I had a valid insurance. You know that I provided the answers from the state authorities in order to draw a connection between me and the prosecutor. Moreover, when it comes to the claim that in 2020, was it 2020 when I bought the car? 2021. That I purchased the car. 2021, yes. So I purchased the car from a prosecutor who was appearing before me. You noticed in the answers from the inspection, from the judicial administration, that the requests made in 2021 were after not after she sold, but after I became the owner, sometime after I even became the owner of that car. So I couldn't have foreseen, according to the standards that according to which we work, because all the motions that we examined are distributed based on a program that randomly assigns tasks. So I couldn't have known that in the future I would have to look into certain motions that would involve that prosecutor. Moreover, I tried at the first evaluation, I tried to be honest. I hoped I would be heard. I could have used a tactic that my other colleagues used. I don't know. I did not see anything. I could not, and I hope that in my life I will not have to give up on people. I know this prosecutor. I had some international studies in the Netherlands, even in the University of The Hague and Leiden. These were 2 or 3 weeks trainings. I cannot say that I don't know that person, that I never talked to her or him. There were 3 or 4 people from Moldova all together. We were all talking among ourselves. We were in a foreign country, and we went to other countries where she was also. I couldn't just not talk to her. But this does not lead to a violation of a code of ethics. The fact that I interact with the people from this profession. I took part in a lot of trainings in Sili Institute in Abarole. I was told this was not a violation. This is something that should be possible. But because justice stakeholders are supposed to communicate among each other, but suspicious transactions shouldn't be expressed about me, but about the person that I purchased this from. This was a good faith buyer. He was a real buyer. The fact that he had to leave the country to move to go abroad, he proved that until now he hasn't returned to the country yet. I talked to him, it's not a secret. Once in a while, we discuss. He agrees to provide you evidence that he's in the US. Moreover, reading the information that you submitted to me, you requested information from the US Embassy, but they refused to provide you. And they said that you are going beyond the privacy, the rules, the laws of the country, because they all enjoy or have certain guarantees, and such guarantees should not be violated, and everyone has the right to privacy. If you have doubts that he's in the US, if you have doubts, I'm ready to take a polygraph test. If you have doubts that he's in the US, tell me what evidence you need. A picture that he's by the Statue. From what I know, he's in New York. Do you want him to take a picture by the Statue of Liberty? Or a notary from the US could provide proof. But you shouldn't write things as if this is a hidden crime. Hidden crime is what they made that connection between me and and between me and this car, with this falsified insurance, with the fact that I forgot it, with the insurance, with that it was purchased from an officer. How? In a secretariat that is tested, is professional, with access to all database. They're not making a mistake in the name, but they make a mistake in the identity number, and they're mentioning a person that is a NAC officer. If you think, Miss Nadezhda, if you think I'm wrong, look at the first set of questions. I was accused for buying from EC, NAC officer, a car. I studied all the materials. I didn't find any reference that the car, that EC is a NAC officer. Who drafted that question? What was the purpose of that question? Moreover, going back to my doubts about the secretariat, I could tell something else. If you remember, in the first evaluation, you asked me about a case, some statements in a TV show with the former president of the country. There was an application to another case but I did not examine. Moreover, they were not informed when I got the case materials. I was not provided that information. Moreover, now you provided me the entire case file and no reference to that TV show or that case as me having examined it is there. But it was in the last round of questions and in the public hearing in order to denigrate me and to entrap me. Please check in your database of documents. Where from did you get that information about the TV show with the former president of the country? And the connection with a case examined by me, which was not a case examined by me. Furthermore, with respect to the fact that it's not correct that we're not told who are the members of the secretariat, and I am talking to the OSCE member now. You say that you are supposed to, you say that you don't disclose the name because you want to defend, but tell me, am I a criminal? Can I influence anything anyhow? It's the commission that makes decisions. How can I influence them through the secretariat? But I want to tell you that when subsequently it will be found who the secretariat members are, it will be found that they have incompatibilities. Moreover, when the commission does not exist anymore, I understand all documentation will be disposed of, but no one can guarantee that personal data of me, my family, my relatives, my friends are not stored somewhere, alienated, or multiplied. I did not want to make this public, but I would like to tell you, even in a public discussion that I had with the vetting commission with Mr. Gaskan, it's not possible for someone who is connected to pre-vetting to be in incompatibility. But I'd like to tell you that in 2019, I examined a motion for criminal investigation about a family member. If you can redact it, it couldn't be right for me to say the name, but I have a document here. It was about a search warrant, and you gave to that person access to the entire database about my family, my relatives, all actions about health condition. If you can stop it, then I can say the name if you can cover it in the video. Okay, I will not say.
Mr. Sandu, please, may I briefly interrupt? Could you please try to go back to the question that I raised with you about the selling of this car and focus your answers only on that aspect, please? You still have 3 minutes to wrap up your response to that. Please go ahead.
I will give you the number of a criminal case. It's 21854. Sorry, that was too fast. Okay, you gave access to the entire database with information about me personally, my family, my relatives. I will not say to what relative, a family member of a person for whom I had a criminal prosecution document. I can give you the case number, the name. You can find out from based on the case number of this case. Who is this person? What's the status of that person? And in this way, the security of my family was violated. I talked now to the entire community and to the OSCE representative, and it would be right for us to know the list of all secretariat members, not to influence them. I have never influenced anyone in my life. I don't have such an intention. Moreover, this decision is made by the international members, so I cannot influence the decisions. But the illegalities committed against me will be made public when the right time comes. If it's necessary, they will be invoked in the European Court. And then we will see what solution the European Court would provide. Will they say who had access to information about the family's, judge's family? I think Ms. Nona knows what's the court case law on in this respect. About the sale of the car, I will make a repeated reference to the Supreme Court, which states precisely or expressly. Let me find it. I'm still fitting without my 3 minutes. So it states expressly that so it do not satisfy the criteria for violation of ethical integrity rules as of high severity. They are not considered existing. Once more, if I had any intent to hide the sale of that car, I wouldn't have purchased it on my name. In Moldova, many people, both civil servants, non-civil servants, drive cars based on a mandate document. Oh, the owner is someone else, they just have a right of possession. And if I had any purpose to hide this, I wouldn't have registered it in my name, but I registered the car as my property in my name, and the intent to purchase it happened when it was recommended by my father and my friend, not before. And the interaction I had with the prosecutor, which you alleged, that happened after that transaction. I couldn't have foreseen that I would have to examine any actions related to that prosecutor, and that was only a situation, compounded situation that was made more complex by some false allegations about narco officers and things. That only that could lead to the fact that this is an allegation.
15 minutes are over. Can you please wrap up your introduction to this issue? Okay.
I did not say the name because the gentleman from the recording said that they will not be able to cover it. So to make sure his professional integrity, I don't have any revenge purposes. I will just provide it to you for information. I will tell you the name. But I would like to this doubt was eliminated by the Supreme Court. Moreover, the Supreme Court was very critical about it, and they said that they did not exist any illegal actions. So please check the decision of a constitutional court, and these actions do not fall under the law on disciplinary liability. That is all.
Thank you very much for that. I have a few follow-up questions to you in relation to this issue. In your 2021 annual declaration, you reported the purchase of a Mercedes that we referred to about for 210,000 lei, which is about 12,700 euros. The purchase contract dated 10 November 2021 listed the seller as Mr. IC, a friend of yours, with your father acting under a power of attorney. The car had been purchased 1 month earlier, on 6 October 2021, by this friend IC from NB, a prosecutor in the Anti-Corruption Prosecutor's Office, for 200,000 lei. During 2019 to 2022, when you were working as an investigative judge, NB, the prosecutor, participated in your examination of applications authorizing criminal proceedings. In your response to the statement of facts and serious doubts, you refer to the reply of the Agency for Court Administration of 18 March 2024, according to which, during 2021, the year you purchased the car, the first request from Prosecutor NB was assigned to you on 13 October 2021 and was examined by you on 28 October 2021. You highlighted that the Mercedes car was purchased by your friend IC from that prosecutor on 6 October 2021. In view of these facts, you concluded that, and I quote, "It becomes obvious that at the time of purchase of the Mercedes vehicle by IC from the prosecutor NB, there were no prior connections or information associating you as candidate or involving you in the professional activity of the above-mentioned prosecutor." Now, my questions are the following. According to the information provided on 23 April 2024 by the Agency for Court Administration, during 2019, you examined 7 requests and materials with the participation of Prosecutor NB, and during 2020, you examined 1 request. Is that correct? Please go ahead, Mr. Sandu.
I don't remember. In my activity, I examined over 12,000 cases. 12,000, more than 12,000. I issued more than 12,000 procedural documents, so that you'd know that. I do not remember the date, the time. I'm just informing you repeatedly about it. You are making a connection between me and that prosecutor. In 2021, when the car was purchased by the first person, not by me, I had no request from them. These are not substantive previews. I do not have to examine anything. What would be the purpose for me to hide anything? The fact that I had some criminal prosecution actions some years ago, no, there is no causal link. Moreover, legislation of Moldova, in case of a conflict of interest, that should be declared. But I did not have the purpose. If I had the purpose to do something illegal, to hide something, I explained that before. I wouldn't have registered it in my name. I could have kept driving it, driving that car based on a mandate type of document. Moreover, the fact that he was purchased by my father using power of attorney has a very simple explanation. And you also said that initially the intention was to be sold, and my father was doing that because the person was preparing to leave. He had some emergency. And the fact that it was sold in my absence, it's because it was during business hours. I was at work. That's why my father went there. No purpose to hide anything. If I had a purpose to hide it, I wouldn't have registered in my name. I can take any polygraph test. I have never been in that car before the day I purchased it. I have never been in that car before.
Okay, thank you very much. But going back to that question, so we're not talking about the Agency for Court Administration message from the 18th of March, but from the one of the 23rd of April. And according to that report, and I assume you do not contest that report, you did examine 7 cases in the course of 2019 and 1 case in the course of 2020, in which that same prosecutor we are talking about did appear. So we can hereby establish that prior to the moment you and your friend first, and then you purchased this car, you had interactions with that prosecutor because she, as a prosecutor, appeared before you. Can you confirm that?
You are not saying things correctly. I interacted in not only 2019 and 2017 and 2015 in trainings. I told you, I am not denying that I know this person. We had trainings in The Hague in the matter of
Mr. Sandu, I'm not
we were
talking about
4
trainings.
people.
Mr. Sandu, I'm not talking about trainings. I'm talking about a situation where this person, as a prosecutor, appeared before you as a judge, as an investigative judge. That is the situation we're talking about. We're not talking about trainings in whatever part of the world. We're talking about this very specific case, and the report from the Agency for Court Administration establishes that prior to the moment you purchased that car from this prosecutor, you had that same prosecutor appear before you as investigative judge for at least 8 times. I would like you to just confirm that that is the case based on that report. Yeah?
1 or 2 years before that, right?
1 and
Is
2
that right?
Yes. But it is before the moment you purchased the car.
1 or 2 years, yes. Look, I have never bought a car from a prosecutor. I did not have any agreements or negotiations with any prosecutors to buy a car. This connection between me and knowing and those criminal prosecution actions, that connection of my professional work related to this prosecutor cannot be drawn. Again, I had criminal prosecution actions with all prosecutors in Chisinau municipality, all prosecutors in the specialized prosecutors' offices. With them all, I had professional activity, but I had no connection, no economic or financial or real kinship relationship with any of them. So this causal effect, causal link between me and her from a financial point of view cannot take place. I did not have any agreement. I did not have any transaction. The fact that this car in 2010, when it was manufactured, belonged in Germany to an attorney is not connected to me. The previous owners have no connection to me. I did not have any economic, social, or civil transaction with that person. And once more, I would like to mention the decision of the Supreme Court that states that there did not exist any doubt. There can't exist any doubt. Moreover, the decision of a constitutional court that in order to invoke the severity of an ethical violation, it has to be reconciled with the law on disciplinary liability. And the actions that you try to allege now are not provided for in the special law on the disciplinary liability. If it happened, if as you wanted, and if some other ill-intended people wanted to frame me purchasing an insurance purchase from NAC officer, that does not fall under the disciplinary liability according to the legislation of Moldova. Maybe in a country, I don't know in what place in the world, that could fall within these legal boundaries, but the legislation that I follow, the law on disciplinary liability, does not apply to this Article 4, prime and 6. So please, for the future, let's follow the decision of the Supreme Court, decision of the Constitutional Court. Moreover, do not invoke this connection between me and the person who is a prosecutor. Speaking of civil actions, understandings, and transactions, I have never had with that person, and I hope I never will.
Okay,
That was all. Thank you.
I have another follow-up question to you. Your friend I see explained during the initial evaluation that he sold you the Mercedes car because he urgently needed money to emigrate to the US. According to public information on obtaining a US visa, there are 12 steps in total required to obtain a visa, and a period of more than 60 days is mentioned between step 11 and 12 only. IC bought the car on 6 October 2021 and left the Republic of Moldova 2 months later on 6 December 2021. It is therefore highly unlikely that he did not apply for an immigration visa to the US until 6 October 2021, when the car was purchased, and was able to obtain a visa and emigrate within 2 months. What do you have to say in relation to these circumstances? Please go ahead, Mr. Sandu.
Look, according to the law of Moldova and international law, every person is accountable for their own actions. So you're asking questions that don't have to do with my work and my life, but I will only provide you an indication. You, not you personally, but you as an institution, as a commission, have erroneously reported this information. Why do you think he had a visa to go to the US? Why did you think he traveled there on the basis of a visa? I don't have the right to talk on behalf of him. You've sought the information from the US Embassy. Did they give you any response whatsoever? Everything that I can tell you is that that person did not emigrate on the basis of a tourist visa and no other type of visa. That is up to him and his life. He talked to his counsel in the US, and they stated they will not make any statements because it is not clear what the legal procedure is. They don't know, they're not certain about the security of his statements and his security altogether. So that's why he refused to make any statements. Still, if you have any questions to him, he is an adult who is mentally fit. You can ask him. If you don't trust him or don't trust me, you can talk to state institutions. There is a representative of the US with you. She can make a file request with the institutions. The fact that the embassy refused to give you any information, it doesn't mean that there is anything to hide, right? And again, I would like to reiterate that nobody pursued the goal to do anything illegal or to hide anything. As I worked as an investigative judge in exceptional cases related to the national security, given that, believe me, trust me, if I had the purpose to hide anything, I would have hidden it, but I've never hid anything. Every asset that I've had, that I drove, that was always declared. Even there was a period of time when I've exchanged my car with my mother's for technical reasons, because she was more comfortable driving the other car. So in my declaration, I stipulated that I've exchanged for a temporary period of time. I've exchanged my car for my mother's for a short period of time. I didn't sell it. It was for about half a year. I was driving her car and she was driving my car. And I didn't even hide even a piece of information like this. We didn't have a contract whatsoever for that. I was always transparent and I never wanted to hide anything. If I wanted to hide it, I wouldn't have written my name in relation to the cars. And the fact that I was open and I told you that I knew that person, I made a phone call, I asked questions that showed my openness. I could have just said that the car was purchased on the basis of an ad. But I wanted to be honest, to be open, and to be very truthful. Everything, to state everything as it actually happened. And nothing was distorted or embellished. That was a real-life situation that I reported to you. And I continue to believe that both the Constitutional Court and the Supreme Court of Justice have provided an explanation as to the doubts. They don't exist at all. It's not them about having a higher or lower degree of severity. There's just no doubt whatsoever. And if you keep pushing or insisting on examining certain doubts, then also look for the intention. Did I have the intention to hide anything? If I had the intention to hide, I wouldn't have written my name under those assets. I could have asked a relative of mine and just still use the car, for instance. Did I have the intention to report to you anything else but the truth? I don't think so. If I had it, all of this wouldn't have happened. That's all I wanted to say in this regard.
Okay, thank you very much, Mr. Sandu. I have no further questions in relation to this issue. Any of the, Nadezhda, please go ahead.
Domnule Sandu, aș aprecia dacă
Mr. Sandu, I would appreciate it if you could provide clarification with regards to, if I got it right, you stated that the financial transactions between judges and participants in proceedings, such as counsels or prosecutors, that they are absolutely allowed by the national law, and that includes the ethics code of judges, and that it's not at all a matter for a judge to engage in a commercial transaction with the parties to proceedings without declaring or reporting a conflict of interest. Did I get this right from you, or is it something else that you wanted to say and I just got it wrong? Madam Nadezhda, did I have any economic transaction with any participant in the proceedings in Moldova? Just that's how you seem to have stated it. I stated that what you have found with regards to myself can not be seen through the lens of the law on disciplinary liability. And I hope this can be properly interpreted as per the law, as per the and in Romanian language for the constitution. I want to say it again. I have never had any civilian, commercial transaction with any of the participants that I've been examining as a judge. I've never had any transaction with a law professional, just to be blunt about it. With regards to the purported connection between myself and the prosecutor, I've already explained that those requests back in 2021 and the transaction took place in October. If I'm right, the first purchase, I mean in October. Then 10 months until then, I've had no criminal case with that prosecutor. How could I have foreseen that I would have one in November? If that would have happened when I was looking at that application, that request, then that could have been that could have given some reasons for doubts, but there was nothing of the kind. I continue to insist on the observance of the Constitutional Court decision that makes reference to the provisions of the law on disciplinary liability, and also I insist on the observance of the decision of the Supreme Court of Justice. I violated nothing. I engaged in no transaction. I engaged in no negotiation, any commercial negotiation of civilian nature or whatever other nature. I've engaged in no such thing with a prosecutor. And to be broader, so to speak, if there's any other doubt, never in my life have I bought not even a phone, not a pen, and no clothes. I've never bought anything from law professionals.
Okay. Thank you. Then we can move on to the third and last issue for the discussions for this afternoon. Please go ahead, Tenona, you have the floor.
Thank you. Greetings, Mr. Sandu. Issue number 3 concerns extension of pretrial detention of Sergei Kosovan in spite of his terminal illness and insufficient reasons given for extending his pretrial detention. In relation to this issue, the Commission has serious doubts about your ethical integrity because you did not satisfy the positive obligation to prevent Mr. Kosovan's distress at an intensity exceeding the unavoidable level of suffering inherent in detention under Article 3 of the European Convention, and because the reasons for ordering Mr. Kosovan's detention were not sufficiently based on evidence in the file, and the justification for Mr. Kosovan's extended detention had not been convincingly demonstrated under Article 5 of the European Convention. In particular, the Commission has serious doubts about your ethical integrity because you did not take into account the terminal illness of Mr. Kosovan, both in terms of its compatibility with prolonged detention, as well as the factor in assessing the likelihood of Mr. Kosovan to abscond or interfere with the investigation. You did not consider whether Mr. Kosovan's continued detention was compatible with his health condition, because according to the European Court's case law, in particularly serious cases, the proper administration of criminal justice requires remedies in the form of humanitarian measures. For example, applying alternative measures to pretrial detention, as was done immediately by the judge that was assigned to examine the pretrial detention requests after your recusal from examining the criminal case of Mr. Kosovan. You had the obligation in your capacity as a judge to play an active role in protecting the rights of Mr. Kosovan. You had to ensure that you provided a clear and reasoned basis for your decisions. The Commission has also serious doubts regarding the manner in which you communicated with the prosecutor about the pending case which led to your recusal. There was no requirement for you as a judge to pass to the prosecutor the letters from the Superior Council of Magistracy or the Parliament's decision. Even in your version of events, that the documents were provided to the prosecutor through your clerk could be an improper ex parte communication, since the clerk cannot do what the judge cannot do. Your clerk's call to the prosecutor invoking the need to provide the two documents cannot be explained reasonably except for your intention to indicate to the prosecutor your intention not further extend the pretrial detention of Mr. Kosovan. If you so wish, please briefly provide additional explanations to complement your written response to the statement of facts and serious doubts. You have 15 minutes for this purpose, and of course, you don't need to use all those minutes if you don't need one. Thank you.
Nona, I've heard you in translation. I did not manage to hear what you said in English, but out of the translation interpretation, it appears that you've already established everything. That I did not do this, that I did that I violated the ethics code, that I violated the imperative norms, but where did this come from? How did you establish this? On the basis of what, if it's not a secret? How come? I mean, everything seems to have already been established.
I just read doubts as expressed by the Commission in the addendum that was sent to you on 15th of May. I did not read any other document, so this is the document that was communicated to you more than 1 month ago.
Just asked him to keep the microphone closer. Thank you. Nona, you did not expose some doubts, but as per the translation, the interpretation, or maybe I could listen to it again in English, you practically established a fact that I violated this, that I did that. I would like to know who was the one who established that I committed those, what was alleged. In order to be able to defend myself, I need to know who made those establishments. Do I have the right to defense? As far as I understand, my lawyer cannot get involved just to assist. Not a problem. But still, I will raise this later. I will mention it. But I would like to know who made these findings, who established it so that I could defend myself.
Mr. Sandu, I just can repeat again that it was communicated to you as a part of the serious doubts. You wish to consult your attorney, as we already suggested to you. We can take a pause and you can have this consultation right now.
No, I want him to be present and active in the hearings, not to take breaks. So did you say 15th of May? The 15th of May, did you say?
Yes.
That is the date.
Yes, we communicated.
Let me have a look then.
Mr. Sandu, I can confirm that in the English document, as I have it in front of me, and which was read out by my colleague Nona Tsotoria, it is regularly quoted as the Commission has also serious doubts, etc. So it is the formulation of the doubts we have expressed in the document that was sent to you, nothing else, of course, and it goes without saying that any determination does not take place prior to the hearing, but only after the hearing will take place when we will deliberate. But as such, all these statements are statements of serious doubts that we have with you, and on which you have the opportunity to answer and take 50 minutes in order to reflect on all the aspects that we presented to you.
I understand your procedure when it comes to recusal is your know-how, and I will not be able to resort to that. But when it comes to doubts and findings, these are two different things. The findings can only be established by institutions that are empowered to do so by law. I will be then very brief. First of all, I will say that you've made all of this, you provided all of this information, but do you know that what was raised with regards to Cerdo that has to do with a number of criminal cases? Are you aware of the fact that Mr. Kosovan was actually concerned in several criminal cases? He was convicted not for the case that I was in charge, but something else. Do you know that he was apprehended in the penitentiary that is at the ECHR? There was something that was not related to the case that I've looked into, but something that happened already after I was not in charge of that case. So what the ECHR looked at, that had to do with the ensemble, with all his interaction with the judicial system. It was not related to my case specifically, but then this is again misleading, same as with the way it happened with the president of the country. Several cases were actually taking place, but reference is only made to the case that I was appointed to. But I will go back to this a little bit later. As far as I know, you might not know all of the details that I've just mentioned. The ECHR actually makes reference to other criminal cases. So ECHR makes reference to the fact that he was convicted for debt, and that case I was not in charge of. It was a totally different case, not the one that I was looking at. But it's not about this. We are just doing the resumed evaluation, aren't we? So let's observe the regulation that was drafted by you, that you participated at, Article 19, because in order to defend myself, I look at the law and I prepare my tactic of defense. So I looked into the regulation that you have drafted, and in that regulation, in item 19, it is stated in letter B that the Commission can send questions, requests to the candidate in so much as that is necessary to clarify aspects that come out of the decision of the Supreme Court of Justice. Article 16, paragraph 1, letter C of the regulation applies mutatis mutandis. So this aspect, when it comes to the initial evaluation, that was not something that was evaluated. Given that this is a resumed evaluation, we cannot look into things that were not addressed as such as the initial evaluation. Otherwise, this would be a vicious circle of examination, and this would also mean differentiated treatment compared to other participants who have passed the evaluation. But you're not, are you looking at what people are posting online now 1 year later, for instance? Or taking some action on the basis of some post on Facebook, or like 4 years later, 2019, 2024, if we count, I mean, that information that appears on the 31st of March, that information that appears that the international members who do not know the state language, surprisingly, meet online. And I have been looking into more than 12,000 cases in my experience. And in all of my work, you were only able to raise issues with 3 cases. And none of the institutions, no court of any level, no inspector, no inspection has found a violation in terms of the actions that I've undertook. I believe that considering the object of my reevaluation, in this regard, you cannot raise any issues but those that were raised in the initial evaluation. Therefore, this matter is not to be an object of evaluation now, because that shows an equal treatment if you compare me with other candidates. More than that, I have to inform you that a person who examined some criminal cases regarding that person, as I too was in charge of the criminal investigation when I was a judge on the merits. So that was a person who underwent the vetting. And this matter was also raised. Do you know the judge from Italy who stated that there was no violation, and the matter of passing the evaluation? Well, the Supreme Court of Magistracy has annulled that. And what they raised is that there has been some violation in the conduct of the judge who was examined, some requests with regards to the gentleman who had already passed away. Just so you know. I mean, if you need to know more, I can share that with you. There is some information that is absolutely public. It's on the vetting website, and you can also look up the decision of the Superior Council of Magistracy that annulled that report. And the judge from Italy established that there was no violation. With regards to what was established by the European Court of Human Rights, you stated that these were established with regards to myself, which is wrong, and this is misleading public opinion, and you were misled too by whoever made that information available to you. You can look up that information. I think it's public, or you can look this up with the SCM. There were several complaints filed with regards to that case, and they were all declared unfounded as far as my actions are concerned. Now, in terms of, because you've stated having some doubts, you've made some findings as to myself having committed some illegalities, that I've presented some information to the prosecutor, I would like to let you know that I do not submit and present the information. All this information is provided ahead of time through the secretariat, and that's the clerk who is in charge of that. And then that information is shared with all the parties, not only to the prosecutor, to all the parties concerned. What is more, no institution from Moldova has established any procedural violations on my behalf. No institution has established any violations regards my professional ethics. In this case, the former prosecutor general has gone all the way to the Supreme Court of Justice. No institution has established that I've committed a violation, neither the disciplinary board, nor the Superior Council of Magistracy, nor the Court of Appeal, nor the Supreme Court of Justice. What security of legal relations could we talk about if for years no institution has found any violation, and then the fact that somebody just wanted to cause me some professional trouble or inconveniences. They wanted to do that, but they did not manage to. I used my legal right of defense, and I will continue to resort to that. Regardless of what will be claimed, I will look into the legal implements out there, and I will use all of them to defend myself. I do not believe I committed anything, and so please no longer come with findings that I had violated something that is subjective and that cannot take even place if what the referral is about is something that I did not participate in. I mean, all that information, there were other cases that were actually at issue, not mine particularly. And I would like to continue. You received that request that I've examined with regards to that gentleman, but you did not look at the fact that I provided him the possibility to be actually investigated in other public hospitals, civil hospitals. Let me see. There's a ruling. I prepared it because I was certain you will try to attack me in this way. Just give me a second. There is a ruling of mine. I will tell you the date. And I've accepted practically that if he needed some additional investigations, medical investigations outside the penitentiary, that he could go elsewhere. And he used that possibility. He's had health checks in several hospitals of Moldova, civil hospitals. And that on the basis of authorizations that I've issued for that purpose. So Toma Ciorba Hospital, for instance, I gave him the possibility to go there. Then he went to hospital number 3 as well for consultations, for health checkups and consultations. And this ruling doesn't seem to have been provided to you. I think you were just shown what whoever wanted to show you decided to tell you. So in this regard, I would not want to make other comments because there were inspections, the Superior Council of Magistracy looked into that already, and I have respect for his family and respect for his honor and dignity, and for that reason I will not engage in polemics to try to persuade you about the need of arrest, of extending the arrest, and what were the actions and arguments and the reasons and the risks of him absconding. And I will not do that for the reason that he has already passed away, and for respect to his name and the reputation of his family. But I would like you to know that that cannot be an object of this resumed evaluation that is against the principles provided for in your law and what was established by the Supreme Court of Justice and the Constitutional Court, meaning that this is differentiated treatment compared to other candidates who have already been evaluated.
Și ca dumneavoastră să reușiți în final,
And
aduc cunoștință
Ultimately, I would like to inform you that from a ethical and financial point of view, there can be no doubt raised as to myself. And I would like to know, I would like all development partners to know and the general public to know that in all your work, you have not actually come across a declaration violation. You have not found any issue with my asset declaration. You've not found any asset, movable or immovable, of my family, of my relatives, the origin of which cannot be proved. I know that Mr. Heppel, in an interview, you mentioned that the resumed evaluation or that the people failed the integrity check has proved that in the system there are corrupt people. So I'm really keen to know. Let me see. There are some statements and that about these corrupt people. It's an interview in Russian. And the fact that this evaluation has proved that has brought forth all of these issues and problems in the system. So I'd like to ask you, Mr. Herman von Hebel, what corruption acts was I involved in? What assets do I own? I've worked for more than 10 years in the judicial system. I was appointed, at that time I was one of the youngest judges, appointed as a judge in the central sector of the capital city of Moldova, and I've worked in high-profile institutions. I don't own assets. I didn't own assets. I had not owned any assets in that period of time. I did not earn a wealth. But you stated that the fact that people failed the evaluation, it means that people in the system are corrupt. And then is another interview from the Netherlands that I've read recently that we are supposed to prove where we have houses from and how did we afford expensive cars. I have a car that is 14 years old. And this is true. It's not hidden. It's not like having a relatives involved with that and owning some real estate. I don't have that, and neither do my relatives. But I'm happy with the asset that I have. I can't claim that I am poor. Not at all. I'm happy with what I own, with what I have, with the assets that belong to me. With regards to the ethical integrity, the Supreme Court stated specifically how things should be interpreted about the car. There can be no doubt whatsoever. Now, the matters that you've raised now regarding the car, regarding this case, I believe this should not be an object of examination, of evaluation at all. I just don't want to go in the details of it out of respect only, because my defense now will be unfavorable to the reputation and the name of that person. I think it's not worth it. This is not the goal, the purpose. Now, with regards to how this information was made known, it's the same as with the president of the country, and again, information was misled. Several cases were reported on actually, but the connection was only made with me only, not with all the other stakeholders. But so far, you still were not able to answer how this information came into this resumed evaluation dossier of mine. This is not in the dossier, in the evaluation materials. Where this information came from? Who made all of these connections with me specifically, for instance? We will never, I guess, find out the answer to that. And I guess we will not know what was the goal pursued with this case, why reference is made to myself, since I am telling you there were at least 2 or 3 criminal cases, and he was convicted on the basis of a different criminal case.
Mr. Sandu, can you please wrap up your answer to the decision number 3, because your 15 minutes are over. Yeah.
I have nothing else to add.
All right. Then, Nona, please proceed. Go ahead.
Before proceeding with the questions, allow me to read again the legal basis for the Commission regarding issue number 3 that was communicated to you, Mr. Sandu, along with the addendum to the statement of facts and serious doubts. So let me read this answer again. Regarding the legal basis for the Commission's requests regarding this issue, which was questioned by you in your response to the Commission's questions on this issue sent on 8 April 2024, the Commission reiterates that Law number 26 2022 does not limit the resumed evaluation to issues examined upon appeal. Article 14, paragraph 10 of the law number 26 of 2022 provides only that the rule on integrity evaluation accordingly apply to the resumed evaluation. The Supreme Court of Justice Special Panel in the decision of 1st August 2023 regarding you stated that, quote, for reasons of effective judicial review as well as of the quality of the law, the Commission is not obliged, after it is ordered to resume the evaluation procedure, to inquire about other circumstances than the ones underlying the acceptance of the plaintiff's appeal. End of the quote. This wording does not oblige, nor does it prescribe the Commission to limit to the issues examined during the initial evaluation. So this was the answer provided to you, which the Commission retains at the moment. So now allow me to ask you questions concerning issue number 3. Mr. Kosovan was detained from 26 September 2017. Is that correct?
I don't know. When the case came to me, he was already detained. I have no idea when the detention started.
Okay. Mr. Kosovan was suffering from a number of serious diseases, among others confirmed by a medical report of 28 May 2016 and the doctors of the penitentiary institutions number 13 and 16. These medical reports were in the file when this case was allocated to you and when you issued your decision of 24th November 2016 extending his arrest. Is that correct?
I think you didn't hear me. I will repeat it. Pre-trial measure is applied when risks exist, so that you know. Preventive measure, pre-trial arrest is and that is European practice. It's European court practice. The pre-trial arrest is not a punishment, is applied to clarify some risks. When it comes to the health condition, I explained to you I don't have the case materials. Wait, once more. This case with the Court of Appeal, do you know about that? The case that I was part of, not other cases, but the one that I was part of, is now with the Court of Appeal. It is a pending case. Do you want now to go into the merits of a case, of a pending case? Is that right? Do you want to do that now?
No.
No,
you want me to provide you arguments. Miss Nona, please, you make reference whether these documents were part of a file. I would like to inform you that I tried to find this case file in the archive, and I was told that the case is with the Court of Appeal, which means I was deprived of the right to get familiar with the case materials. Miss Victoria is lost. I think she'll see the recording. I was deprived of the right to get familiar with the materials and to provide you evidence. I don't have the case. The case file is pending before the Court of Appeal. So you want me to motivate my solution on a pending case. That's the first thing. Secondly, in other situations, I don't want to claim attack or something, but when a person was asked about a pending case, she said, we cannot discuss about it because it is pending, about a relative's case. But now you put me for the second time in this situation during the initial evaluation. It was about a pending case, and I'm really interested. What will Supreme Court judges decide after you put in a public discussion, not in a closed hearing? You doubt the legality of evidence in that criminal case. I am really wondering about that. Miss Nadezhda, what do you think? Is that right to discuss now publicly a pending case and my actions in that case? Mr. Sandu, we are not talking about the case on the merits. It is not being the menace to extend the detention is not examined in the Court of Appeal. It's about the accusal, well, what he's accused of. So we're only talking about the pre-trial arrest. No, Ms. Nadezhda, according to Criminal Procedure Code, the judge can issue an opinion about all the aspects of a case, including the merits. So a judge at the Court of Appeal can look into some actions that were undertaken at a lower level, that were the legality of which was already reviewed in a regime of 3 people who were reviewing such second appeals. It's not a problem for me, but my question is, do you want to discuss that in a public hearing? Is that a fair attitude towards me? When you were asked about the situation, you said it's a pending case and you don't want to discuss about that because that's not correct. What will be the solution of the judges who are reviewing the merits of this case in the Court of Appeal in Botanica sector? What will be their solution after they see this video and they are undergoing vetting right now? I have, again, a question. What will be the solution of a case that you asked me, about which you asked me in December? It's still with the Supreme Court, it's still pending. It's more than a year, it's almost 2 years since it hasn't been examined. The question, why don't the judges want to examine it? Because you put into discussion evidence and truthful, well, validity of that evidence, and I told them let's discuss it in closed hearing. You said no, so it's not a problem for me to discuss anything. If you want to do that, let's talk, open hearing or closed hearing, but let's decide, do we have to discuss? I don't want to discuss about this from an ethical, moral point of view related to a person that is deceased. If you want to discuss it, let's discuss it. Give me access to the file first. Give me access to the material so that I could provide evidence to make sure that because there are audio recordings. I was telling parties in the hearing that if you need medical tests, file a request and we'll discuss it. He used that right later on. I gave him the possibility. He went to the hospital for some test and then to another hospital for another test. But the preventive measure that I applied was not a punishment. It is applied only in case of risks. And the risks were not related to the health condition. The risk, meaning that there were other risks, not health-related. Other risks were claimed by the prosecution body.
Mr. Sandu,
please, let's clarify that.
Yeah,
so that we can
Mr.
decide.
Sandu, I can clarify. The question that we raised with you is not about the substance of all the medical issues and whatever. The only thing that we asked here, or that Nona asked you just a few minutes ago, was whether in the file, when you were deciding upon this case in the context of pre-trial, whether the medical report was part of the file, yes or no. We're not asking you to go into the into the details of that. We just ask you, was this medical or these medical files part of the file that you had in front of you when you decided upon the case? That is all that we ask. It's a very factual question. It's not about the details of the case.
Tell me, please, have you seen the criminal case? You are asking me about actions that took place in 2017? That is 7 years ago? I don't have access to that criminal case file, and you want me now to tell you yes or no? Is this a tribunal? I just want to understand. Give me my right to defense that I have legally. You didn't have access to that. You don't know what was examined. You were only you only listen to some public denigration, and you make this public trial now, public conviction of a person. This is not the standard of evaluation.
You are aware, you are not in front of a tribunal. You're in front of a pre-vetting commission that is acting under law number 26/2022, and we're asking you questions in relation to material, of which all materials that we are discussing today have been submitted to you in advance, and which you had access to and that you have been able to study. So your right to defend yourself, even though it's not even a criminal proceeding, it's a hearing for the pre-vetting commission. Your rights are fully respected here. All the information that all the questions that we have is in relation to materials that we have given to you in advance. So no violations there. We are absolutely convinced about that. So my question to you is, we can proceed in closed session if you prefer. I don't think we have heard that before, but if you would like, we are happy to do so. But our only question here is, let me finish off my question, please. My only question that Nona put to you is whether, when you looked into the materials and took a decision on the pretrial detention, whether the medical information was part of that assessment. That is all that we ask. Please proceed.
Mr. Hebel, you said that my rights are fulfilled, respect, and you provided me in advance this, and I was made familiar. Maybe I will speak slower so it can be translated. The case is pending. I cannot get informed. In my activity, I don't run copies of case files. I don't keep at home or at work copies of case files. I examined over 12,000 cases in 10 years. 12,000, more than 12,000 of procedural acts issued by me, signed by me. And you are saying that I have free access? The case is handled by another judge now, do you think? Because I went to the chancellor, I put it in the archive. The archive told me that it's pending with the Court of Appeal. I legally cannot have access to that case. It is handled by another judge, and I am not going to violate the Code of Ethics to address another judge and ask for the materials. So I will explain once more. It's not ethical, it's not correct to discuss about a case that's pending before a court that is about to be examined by judges who are supposed to go through the vetting procedure. This can be treated by an independent observers, as you usually say, as an interference with justice. With respect to a closed session, I agree to discuss. It's just we need to make sure what's the format, open hearing or closed hearing. Because in some situations, you say that it's not discussed because the case is pending. But in my case, it is being discussed in a public hearing. You are the ones who decide. You are the body that decides.
No, please go ahead. I see your hand up.
Just before we decide to go to the closed session or not, let me remind you that there is the European Court's judgment concerning Kosovan case. And all my questions that I'm going to ask you is based on public decision of Kosovan versus the Republic of Moldova. So from that point of view, there is nothing I'm going to ask you which is not already in the public domain. So having said that, we still can discuss whether we should go to the closed hearing or not, but still I wanted to mention that before we make any determination about the continuation of the hearing. So even in the court's judgment, there are much more details than I'm going to ask you. We specifically eliminated all possible health-related information, which once again is already in the public domain. So from that perspective, the case that is pending still before the public authorities has no relevance to this particular hearing. So having said that, I can conclude this intervention right now.
Okay. What I would suggest to do is, since there has been some discussions about the scope of this issue, and I totally support what Nona just said, that this is all related to public information as a result of the European Court in Strasbourg's decision. But I would suggest that we break for a few minutes, that the Commission will deliberate amongst itself as to whether or not to proceed, and if so, whether to do so in open or closed session. And then we will come back to you in a few minutes. So please stay where you are, and Mr. Sandu. We will withdraw for a few minutes, and we will be back to you within the next 5 minutes. Okay.
Mr. Chairman, we can resume the hearing.
Okay. Then let's proceed now with the hearing. Mr. Sandu, as you have noted, the Commission has withdrawn for a few minutes in order to deliberate in relation to the question that you raised about the character of the present issue. As you are aware, this is an issue in which you as a judge were involved in a number of decisions relating to the extension of detention of a accused person who at the same time had very serious medical issues. We took this issue in our considerations and in our resumed evaluation, given the seriousness of the case, and also because of the fact that the Strasbourg court, in a public decision, has taken some clear decisions on it, including finding violations of Article 3 and Article 5 of the European Convention. The decisions that you have taken at that time were included in the dossier and were submitted to you. So you may not have access to the entire dossier, but you certainly have access, and you had access because we've provided it to you, all the documentation and all the decisions that you yourself took at that time in relation to this case. The scope of our discussions in principle were related to the entire process at the Moldovan national level, leading up to and including the decision of the European Court of Human Rights. And as you know, decisions of the European Court of Human Rights are always very well reasoned and provide long factual descriptions. So all the facts that we have presented to you are also included in that public document, in the public judgment of the European Court of Human Rights. However, notwithstanding our strong conviction that everything could be discussed publicly, we, out of an abundance of caution, have agreed to go into closed session for the remainder of the questions that we may have with you. But just for public consumption and public purposes, and also the observers that are following our proceedings, we would like to emphasize and we would like to stress that this is all public information. It's included in the decision of the European Court of Human Rights, and that all the decisions that you have been responsible for have been disclosed to you, and you have had access to all that material. That being said, let's go. Let's take 1 minute interruption in order to ensure that we go into closed session now and continue with the discussions that we had with you in relation to your role in this case that, as we know, led to the decision in Strasbourg finding violations of Article 3 and 5 of the European Convention of Human Rights. But let's briefly interrupt and let's wait for the signal that we can proceed in closed session. Mr. Sandu, as per usual, we end the hearing with giving the candidate an opportunity to make a brief closing statement. Given the fact that we have been having this hearing for the last more than 4.5 hours today, I would like to emphasize the word brief in brief closing statement. So please go ahead if you would like to make a brief closing statement. Mr. Sandu, you have the floor.
Eu vă mulțumesc.
Thank you.
Va fi foarte succint.
I will be very brief.
Eu vă
It's
mulțumesc
been a
pentru
long
audiere.
time indeed. Thank you for the hearing. I hope I was heard.
Vă urez succes.
I wish you good luck, and I look forward to see your solution.
Mulțumesc.
Thank you very
Thank
much,
you.
Thank you very much, Mr. Sandu. Whenever I used to work in diplomatic meetings and someone started off by saying, I will be brief, the first thing you always knew was he or she was not going to be brief. So when you started off by saying this, I got worried, but you absolutely delivered to your promise and you stayed very brief. So thank you very much. This comes to the end of our hearing today. As you know, the standard procedure is that we will withdraw for deliberations and prepare a decision, and we will try to do so as per usual within a month from the date of this hearing. Thank you very much for your presence today and for answering all our questions. It has been long for all of us, but thank you again. With this being said, I would like to close the hearing for today. Thank you very much.